Assalamu alaikum and a very good evening to you all. Welcome to the final of the Citibank BIAC International Inter-University Arbitration Contest 2021, organized by Bangladesh International Arbitration Center BIAC and supported by Citibank Limited. Bonik Barta is the media partner of this event, and this program is being live streamed in BIAC and Bonik Barta's online Facebook page. On the occasion of this event, BIAC published a special publication. Many of you have already received this publication, and those who haven't will receive it soon. I'm Mahbuba Rahman Runa, General Manager of BIAC, and I have the honor to be with you throughout the session this evening. Dear all, last year, we organized the first ever arbitration contest for university students in the history of Bangladesh with an aim of organizing this contest in the upcoming years. Keeping this in mind, this year we arranged a more broad-based first international contest in Bangladesh where 7 leading international and national universities are participating in this contest, which are BIAC Academy Bangladesh, University of Chittagong Bangladesh, Damodaram Sanjivaya National Law University India, last year's champion University of Dhaka Bangladesh, Independent University Bangladesh, Lahore University of Management Sciences Pakistan, and London College of Legal Studies South. In the first session of the preliminary round, where London College of Legal Studies South won the session against Damodaram Sanjivaya National Law University India. In second session, where BIAC Academy Bangladesh won against Lahore University of Management Sciences Pakistan, and in the third session, Chittagong University Bangladesh won against the team of Independent University Bangladesh. Following that, in the semi-finals, University of Dhaka and University of Chittagong qualified for the final. Today, in the final, we have University of Dhaka as the claimant team and University of Chittagong as the respondent team will be striving for the champion trophy. Before we move on to the main contest, it's my pleasure to introduce the 5 participants from University of Dhaka and 4 participants from University of Chittagong. Representing University of Dhaka team, Mr. Ahmed Ragib Choudhury, Ms. Labiba Fariha, Ms. Naushin Noor, Ms. Salsabil Choudhury, Ms. Tasnim Halim Mim. Representing University of Chittagong team, Mr. Arafat Ibnul Bashar, Mr. Akib Tahmid, Mr. Badhan Ghosh, and Ms. Suparna Roy. Both team members will play roles of coordinator, counsels, witnesses for their respective sides. 60 minutes are allocated for each team to present their cases. Both teams already submitted their submissions to the tribunal and the other party. Today, the champion and runner-up team of the contest will be declared at the end of the contest. As our contest is being held from a digital platform, BIAC will arrange a trophy and certificate distribution ceremony at BIAC. Date will be declared later in today's session. Now, we will begin with the welcoming remarks from the Director of BIAC. I would like to invite Mr. M.A. Akmal Hussain Azad, who has been with BIAC since September 2017 as Director. Mr. Akmal Hussain Azad is a former career bureaucrat and was Additional Secretary, Ministry of Agriculture, Government of Bangladesh. He also worked for the civil judiciary for a while before joining administration. Mr. Azad studied law and public administration in the University of Dhaka and the University of Manchester, UK. Sir, please.
Thank you. Good afternoon and good evening, respected Chairman of the Board of the Bangladesh International Arbitration Center, Mr. Mahbubur Rahman, our guest of honor, Mr. Masroor Arifin, Managing Director and CEO of the Citibank Limited, Chief Executive Officer of BIAC, Mr. Muhammad A. Rumi Ali, Dr. Deepak Jindal, Chairman of today's Tribunal of the Finals and Advocate, Punjab and Haryana High Court, Chandigarh, also member, Governing Council, International Center for Alternative Dispute Resolution, India. Mr. Anil Changaroth, member of the Tribunal and Managing Director, Changaroth Chamber LLC, Singapore, and Changaroth International Consultancy, ODRasia and ODRanz, Asia Pacific. Mr. Meng, member of the Tribunal and Director, Alternative Dispute Resolution, Financial Industry Dispute Resolution Center, Singapore. Professor ABM Abu Noman, Dean of Law, University of Chittagong. Dr. Jamila A. Chaudhry, Professor of Law, University of Dhaka. My dear participants from the University of Chittagong and the University of Dhaka. It is said that champions realize that defeat and learning from it, even more than from winning, is part of the path to mastery. From today's finals of the Citibank BIAC International Inter-University Arbitration Contest 2021, either of the participating teams will come out successful, beating the other and win the trophy. The learning from this contest will guide our young arbitrators to find their place in their future professional area, may it be in the judiciary, the bar, the corporate world, the financial industry, or any other stream. I take this opportunity to congratulate both the participating teams, their guides, and our learned friends, the dignified arbitrators who have been very kind to join us from India and Singapore today. By hosting this Citibank BIAC International Inter-University Arbitration Contest 2021, BIAC is trying to draw attention of the business community, the legal professionals, and the financial sector maestros of Bangladesh and the region to the issues and problems of mitigating commercial disputes out of courts, given the backlog of 3.9 million under trial cases in all the courts of Bangladesh only. Our thrust is to generate more awareness about alternative dispute resolution and importance of introducing it to assist our judicial system. It is my privilege to extend our heartiest gratitude to the Citibank Limited and its distinguished Managing Director, Mr. Masroor Arifin, for sponsoring this important event of BIAC. We are optimistic that this contest for students will inspire young learners to bring about the desired change in the global platform of arbitration, aiming at speedy and cost-effective resolution of commercial disputes. In the wake of the COVID-19 global pandemic, students were home quarantined with relatively less pressure of studies, which was a great time to enrich their knowledge and to add a certificate to their resume as to prepare them for professional advancement. BIAC tried to ensure equitable learning opportunities for all the students while prioritizing their health and well-being through online learning. To make this home quarantine productive, BIAC organized the first online learning session for students in mid-2020. BIAC has reacted to the current crisis of COVID-19 and the future new norms for the handling of dispute resolution by quickly converting cases originally slated to be in person to their virtual cost-effective system that allows cases to be arbitrated and mediated through the use of video technology. BIAC invited top lineup of expert speakers from home and abroad in a number of webinars who addressed the key issues on ADR of different sectors, particularly the adverse effect of COVID-19 on many jurisdictions, including Bangladesh. For the first time in 2020, BIAC organized a day-long training for 24 officers of the Legislative and Parliamentary Affairs Division under the Ministry of Law, Justice and Parliamentary Affairs, who are actively involved in vetting laws from all the ministries and divisions of the government. During the last 10.5 years of operation, BIAC inter alia trained judicial officers at their Apex Training Institute, the JATI. We have been working with the Ministry of Commerce and the Ministry of Foreign Affairs regarding signing of host country agreement with the Permanent Court of Arbitration, The Hague. We worked for drafting an ADR guideline for banks to resolve issues of non-performing loans, and the committee formed by the central bank submitted a draft to Bangladesh Bank. We also worked with the Financial Institutions Division towards drafting a new law on transfer of movable properties, namely the Secured Transaction Movable Property Act 2020. BIAC hosted a consultation session for gathering opinion from various strata of the society for drafting the Arbitration Amendment Act 2018 under the behest of the Law Commission Bangladesh. We have advised University Grants Commission of Bangladesh to include ADR in the syllabus of undergrad and postgrad students of law in all universities. We also requested the Bangladesh Bar Council to include ADR in the syllabus of legal practitioners training programs to upscale their professionalism. We cherish support by the government, businesses, banking and financial institutions, the legal fraternity, NGOs, the academia, and the students towards building a prosperous country by contributing our best to our economic development. In a sense, by resolving business and commercial disputes, resorting to ADR methods in general and arbitration in particular. Thank you all for your patience.
Thank you, sir, for your nice words. May I now introduce our today's chairman and members of the tribunal. We are extremely honored to have with us Dr. Deepak Jindal, who is an advocate of the Punjab and Haryana High Court, India. He is a member of the Governing Council of the International Center for Alternative Dispute Resolution, ICADR, and a guest faculty of the Department of Laws, Punjab University, Chandigarh. Dr. Jindal is a mediator and trainer of the ICADR. He also served as Deputy Advocate General of Haryana State. Along with him, today we have with us Mr. Anil Changaroth as member of the tribunal. Mr. Changaroth is a fellow of the Chartered Institute of Arbitrator, Singapore Institute of Arbitrator, and Philippine Institute of Arbitrator. He is the managing director of Changaroth Chambers, LLC, Singapore, Changaroth International Consultancy, ODRasia, and ODRanz Asia Pacific. He is a mediator, adjudicator, arbitrator, and dispute resolution practitioner. He is a barrister at law from Middle Temple, England, and an advocate and solicitor of Singapore and solicitor of England and Wales. We have with us Mr. Ho Ming Hee as member of the tribunal. Mr. Ho Ming Hee is the Director of Alternative Dispute Resolution of the Financial Industry Disputes Resolution Center, FIDReC, Singapore. He is an advocate and solicitor of the Supreme Court of Singapore and a barrister at law of the Middle Temple, London. He also served the government of Singapore as State Counsel and Deputy Public Prosecutor at the Attorney General's Chambers. He appeared as Defense Counsel in the Singapore High Court and Court of Appeal in capital case, among others. Now it is time to start the contest, and I would like to hand over the stage to the chairman of the tribunal and request him to start and run the contest. Dr. Jindal, the floor is yours.
কলা আর বন্ডি 5 টাকার বন্ড আমি ম্যাক্সিমাম টাইমে মিলে খেতাম তো সাথে ভিজে গিয়ে চালাতাম তাহলে এক কাপ চা দিয়ে আগে বন্ড খেতাম আর একটা হ্যাঁ এইটা আমি
Hello, Dr. Jindal.
Dr. Jindal, are you there?
Looks like he's here, but his microphone is muted. I'm not sure if he's there. Give me a minute, please. Dr. Jindal is already there and he has some connectivity issue. He will start the session as soon as he is able to switch on, overcoming the connectivity issue.
I would like to request Mr. Changaroth or Mr. Homing He to start and run the session.
Hello. Yeah. You know, as the time starts at 3:30, we are about 7 minutes ahead. If I could then maybe ask the parties, representatives to have their cameras on and everybody else off. So we would have for the claimants, Mr. Chowdhury, Ms. Faria, Ms. Noor, Ms. Chowdhury, and Ms. Min. Let's see all of you, and then can you label yourselves, because I know one has labeled yourself as C Counsel, another one has labeled yourself as Claimants Counsel. So could you all just put it in system? We only start at 3:30, so we've got about 6 minutes. So if you could all adjust all of that, and then all of you put it into system. I noticed that the claimant's witness has got CW1, whereas the claimant's counsel, one has got it as claimant in full, another has it as C counsel. Likewise for the respondents as well. Could you all put it into the same system as in either your name and with R or C? So we have Sabil, is it Ms. Chowdhury? Can you, yes, change it to C counsel. It's easier to read because it's too long otherwise. All right. Respondents as well. Could you put us as R counsel and both of you? And is one of you the lead counsel? Or both of you the same level? How does it go? Ms. Chowdhury, the claimants?
Your Honor, there is no lead counsel. However, there is a coordinator who will facilitate throughout the session and will assist the court in assist the tribunal in any manner. And I shall be the coordinator for the claimants team.
All right.
During our introduction, we will allocate the roles of each counsel and witness, and we will clarify our stance there. Okay,
so now I see that the claimants have got 3 counsels and 2 witnesses. Is that right?
Yes, that is right.
Now the respondents, you have not put your names in the order as yet. Can I have your surname, and can I have your surname followed by R counsel, surname followed by R counsel? So just your surname would do fine, I think, except that the claimants have got 2 Chowdhurys. Well, one is a gentleman and one is a lady, so it's easy to find. So just put your surname followed by C counsel. So Ms. Chowdhury would be Chowdhury C counsel, and then the other Ms. Noor, right? Would that be right? I'm just working with the claimants. Don't worry, we still have about 4 minutes left. Yes, Noor C counsel, perfect. And then the third gentleman is, your surname is Chowdhury, right?
Precisely, Mr. Arbiter.
Yes, so change that to your surname and put C counsel. Now I'm coming to the respondents. I hope you catch up fast enough. Where are the counsels for the respondents? Where is Mr. Tamid? Mr. Tamid, could we have your name put as Tamid, our counsel? And where's Mr. Bashar? Where's Mr. Bashar?
Yes, sir.
Yeah, just put your surname, take away the rest of your name, and then you put our counsel. That's fine. Thank you. Then
Okay,
Mr. Ghosh, where are you, Mr. Ghosh?
Yes, sir. I'm just
Yeah.
telling my.
Yes, please. And then Miss Roy, where's Miss Roy? Mr. Ghosh, if you're the witness, can it just be Ghosh, open bracket, RW1 or 2?
Yes, sir.
And then Mr. Roy, just put Roy would be fine. Your surname is just fine. Just Roy counsel, because you know the name is too long for us to follow.
Yes,
Thank you. Bashir has got it right. Oh, sorry, Miss Roy. My apologies. Just put Roy bracket our counsel.
Yes, sir.
And Bashir is SEL at the end. Counsel. And the witnesses, where are the witnesses? Yes, we got RW1. Is there an RW2? Is there an RW2? Dr. Deepak, I'm just putting I'm just getting the formality, get them in, all in name.
Thank you so much, Mr. Anil. Thank you so much.
No worries. We're just a minute away. We're just a minute away. I'll just check whether we've got all of them in order. Let's see now. We start with the claimants. We got counsel, 3 counsels, and 2 witnesses. And the respondents, we have, hang on a second. 2 counsels, one of them is missing, is it? And 2 witnesses, is that right?
So we have 2 counsel and 2 witnesses.
Yeah.
Total 4.
Where's Miss Roy? We seem to have lost Miss Roy, right? Would I be
Yes, sir.
right? Okay. And you've got both your witnesses ready. So we are almost there. We just need Miss Roy back, and then we'll be ready to rumble. Yes, Miss Roy is back.
Extremely sorry, sir. There is network issues. So
No worries, no worries. We're just in time and just ready to start. Once your cameras are on, Mr. Ghosh and Miss Roy, and then we're ready to go. Okay, over to you, Tribunal Chair. We're got them. Dr. Deepak, we're good to go.
Yes. Anil, that's great. Thank you so much. So we can start the contest now.
Yes.
Yes, for claimant, kindly start. So your opening statement.
Honorable arbitrators, I was supposed to do the introductory speech on behalf of the claimants team as the coordinator to allocate our roles. May I proceed with that first?
Okay.
Much obliged. Honorable arbitrators, a very good afternoon to you all. I am Salsabi Chaudhuri, the coordinator of the claimants team. I, along with my teammates, shall represent the claimant, Sino Limited, in this arbitration proceedings between Sino Limited as the claimant and Pfizer Real Estate Limited, or as known as FREL, as the respondent. We have total 5 members in our team, 2 witnesses and 3 counsels. Ms. Tasneem Halim Mim will play the role of claimant's first witness, Mr. Rasal Ahmed. Ms. Labiba Fariha will play the role of claimant's second witness, Mr. Ghulam Kipriya. Counsel Mr. Ahmed Raghi Chaudhuri will present the opening statement for 10 minutes and conduct the chief examination of Mr. Rasal Ahmed for another 10 minutes. Counsel Ms. Naushin Noor will at first conduct the chief examination of Mr. Ghulam Kipriya for 10 minutes and also conduct the cross-examination of respondent witness Mr. Akib Tahmid for another 10 minutes. I counsel Salsabi Chaudhuri.
All the contestants to please strictly adhere to time limits, kindly. This is my request. Okay, please carry on.
Much obliged, Honorable Arbitrator. We would surely try our best to do that. And I, Counsel Salsabi Chaudhuri, will conduct the cross-examination of respondent witness Mr. Sharik Chaudhuri for 10 minutes, submit the closing statement for 10 minutes, and as I have already mentioned, I shall play the role of a coordinator throughout the session. Honorable arbitrators, we humbly seek your permission to share our screen from time to time in order to refer to the relevant documents and pinpoint relevant information. May we please have your permission?
Yes, please.
Much obliged. Now, with your permission, honorable arbitrators, we would like to call upon our first counsel, Mr. Ahmed Rabi Chaudhuri, to start with his opening statement.
Honorable members of the tribunal, may I proceed with my opening statement?
Yes.
Much obliged. Honorable members of the tribunal, a very good afternoon to you all. I am Ahmed Ragib Chaudhry, counsel for the claimant side, Sino Limited, in today's arbitration proceeding between Sino Limited and Pfizer Real Estate Limited, also known as FIDReC, and I shall be providing the opening statement. At the outset of the opening statement, honorable members of the tribunal, at first I want to submit a brief factual summary. On 3rd March 2017, Sino Limited and FIDReC entered into a deed of agreement for the FIDReC project, under which Sino Limited was required to demolish the FIDReC project at 67 Dhanmondi, Dhaka 1205 and hand over possession of the land to FIDReC. And FIDReC was required to obtain approval of the building plan from Raju to construct a minimum 12-story commercial building on the said land, pay 30 million taka to the claimant as signing money, and arrange alternative office accommodation for Sino Limited at its own cost entirely. However, the respondents denied to perform their obligations under the deed of agreement on multiple occasions. They made demands contrary to the provisions of the deed of agreement and abandoned the project. Upon failure to amicably settle the matter due to the non-cooperation of the respondents, the claimant decided to proceed to arbitration under clause 37 of the deed of agreement. For your ease of reference, I shall split my arguments into two segments. Firstly, addressing the procedural issues. Secondly, then moving on to the substantive issues. Under the procedural issues, I have 4 points to address. Firstly, the jurisdiction of the tribunal. Thereafter, seat, language, and cost of the arbitration. Regarding the jurisdiction, the respondents have already agreed in this matter in page 12 of the written submissions that the tribunal constituted by BIAC as per BIAC Arbitration Rules 2019 has the jurisdiction to hear this dispute. Claimant sent a notice for arbitration to the respondent on 10 October 2021, wherein the claimant proposed that the arbitral tribunal proceedings be governed by BIAC Arbitration Rules 2019 as stated in Exhibit 39. Though the deed of agreement stated a three-tier arbitration process, the claimant moved on to the third step directly, which has been agreed by the respondent in response to the letter as stated in Exhibit 23. Therefore, as both the parties have agreed to the BIAC Arbitration Rules 2019 to be the applicable law to the arbitration proceedings, it is the humble submission of the claimant that the arbitral tribunal has the jurisdiction to hear the dispute under BIAC Arbitration Rules 2019. Regarding the seat of arbitration, the claimant originally proposed Dhaka, Bangladesh as the seat of arbitration. However,
apologies. Would the seat of arbitration be your second point in your procedural rules, procedural points? You said you had 4 points to make on the procedural points.
Much obliged, Mr. Arbitrator. Precisely, the seat of arbitration will be the second point. The language of arbitration will be the third point. Much obliged. May I proceed?
Yes, please.
Thank you, Mr. Arbitrator. Regarding the seat of arbitration, the claimant originally proposed Dhaka, Bangladesh. However, subject to the counter proposal made by the respondent, considering the convenience of all, the claimant agrees with the respondent that the seat of arbitration shall be the Zoom platform. Regarding the language of the arbitration proceedings, both the parties have agreed that the language shall be English. And finally, parties have also agreed to be jointly responsible for cost to be paid to the BIAC Arbitration Tribunal for this arbitration proceeding. Now, moving on to the substantive issues before this tribunal, the counsel for claimant would like to divide his entire submission into the following 4 key arguments. Firstly, the claimant performed their obligations under the deed of agreement while the respondent did not. The deed of agreement is a valid and binding contract, and the denial of performance by the respondent is not justified and amounts to breach of the contract. And fourthly, for the acts and omissions of the respondent, the claimant is entitled to compensation and seeks certain relief from this tribunal. Regarding the first issue,
go through the second and third. You had the first point was the fact that you had performed and the respondent had breached. What was your second? What was your second and what was your third point before you came to the compensation, which is your fourth?
Much obliged, Mr. Arbitrator. Our first point was that the claimant performed their obligations, but the respondent did not. The second point was the deed of agreement is still a valid and binding contract. Thirdly, the denial of performance by the respondent is not justified, amounts to breach of contract. And finally, the acts and omission of the respondent entitles the claimant to compensation and therefore seeks certain relief from this tribunal. Regarding the first, much obliged, Mr. Arbitrator. Regarding the first issue, the counsel most humbly submits that the claimant performed their obligations under the deed of agreement. The respondents have also agreed that the claimant, Sino Limited, has performed their part of the deed of agreement as stated in page 16, paragraph 14 of their written submissions. However, the counsel would like to state that the claimant, in pursuance of its obligation under clauses 3, 16, and 24 of the deed of agreement, handed over vacant possession of the land, copies of original deeds and provided power of attorney to the respondent. Regarding the delay in handing over the place, the humble submission of the claimant in this regard is that the delay was justified, as under clause 21 of the deed of agreement, the respondent was solely responsible for obtaining permission for construction related works from Rajuk and other agencies entirely at its own cost. The respondent received Rajuk approval from 22nd October 2019, after which the claimant notified the respondent, vacated the as-status complex and initiated the demolition process on 1st February 2020, and which was halted due to the general holidays nationwide declared by the government of Bangladesh on March 2020. However, they resumed the demolition process on November 2020 and finished it on 15th of March 2021, as stated in exhibits 15, 16, 19, 20, and 21 of our statement of claim. Point to be noted, honorable members of the tribunal, the respondent expressed no grief over the timeline of the handover of possession. Rather, in an email sent by the respondent on 20th March 2021, as stated in Exhibit 10 of their written submissions, they stated that their project manager, Mr. Talukdar, visited the land and gave satisfactory feedback, and the respondent intended to start constructing the building as soon as possible. Such statements suggest that there was no problem from the respondent regarding the delay in handing over of the possession. Regarding the respondent's obligations under the deed of agreement, they had several obligations. Firstly, they were required to pay Dhaka 30 million to the claimant under clause 7 of the deed of agreement. However, as an uncontestable and established fact, the respondent has had made no payments to date and the entire amount is due, as has been established in page 1 of the case for final. Regarding the respondent's further obligations, they were required under clause 9 of the deed of agreement to arrange alternative office accommodation and parking facilities for the claimant entirely at their own cost. Although the facilities were arranged, they reneged in paying rent since June 2021, and the rents of 6 months have already been due, even though the claimant has on several occasions urged the respondent to make their due rentals on time, to which the respondent has remained indifferent. It has been established, substantiated further in the page 2 of case for final and in exhibits 27, 28, 34, 37, 38, and 40 of our statement of claim. Furthermore, the respondent was required to initiate working on the project on 19 May 2021, 2 months after handing over of the vacant possession under clause 4 of the deed of agreement, which they did not. Therefore, it is evident that the respondent continuously committed and reneged to performance part of the agreement on multiple occasions and made proposal for downward revision of financial considerations which were beyond the deed of agreement. Regarding the second issue, the claimant submits that the deed of agreement is still a valid and binding contract. The respondents have accepted and agreed upon the deed of agreement as being valid and binding in paragraph 9, page 14 of the written submission. However, in paragraph 58 and later on in page 4, paragraph 13, they have declared that the deed of agreement has become void on 1st April 2021. They have said, and we quote, the agreement in its current status has been rendered impossible and consequently void due to the COVID-19 pandemic, which will be effective from 1st April 2021. Point to be noted here, honorable members of the tribunal, is that such a claim has never been communicated to the claimant until last week when we received the respondent's response to our statement of claim. After 1st April 2021, much obliged, Mr. Arbitrator, may I have just 30 seconds to summarize? Much obliged. Thereafter, the respondents had multiple communication with the claimant after 1st April 2021, wherein they never stated that they considered the deed of agreement to be void. Moreover, they have also not been able to show that any concrete reason as to why the contract became void on 1st April 2021, when the situation actually improved in Bangladesh, and not why the contract became void back in March 2020, when the government of Bangladesh declared nationwide lockdown. And the only reference of the COVID-19 situation they made was in footnote 15, when they were stated that 8 districts in Bangladesh were to be put under lockdown. However, the area in which our land is situated, Dhaka, was not included in these districts. Therefore, they have also failed to show, as has been stated in the case 2021 case of KL Enterprise versus Bajaj Finance, the correlation of the force measure, the impossibility of performance with the pandemic. Therefore, the claimant humbly submits that the respondents have failed to perform their obligations, that the contract has failed to perform their obligations, and they have failed to facilitate and substantiate the contract becoming void due to force measure, especially since the deed of agreement in clause 29 specifically states that in case of force measure, the parties will solve the problem amicably between themselves, but it does not state anywhere that the force measure event renders the contract as void. Therefore, since Bangladesh government did not declare COVID-19 as a force majeure event, a mere association like rehab, which has no authoritative value, cannot establish the COVID-19 pandemic as a force majeure event in Bangladesh. With that, honorable members of the tribunal, the council would like to conclude his opening statement, and with your permission, proceed to the chief examination of Mr. Russell Ahmed. Relevant facts regarding issues 3 and 4 shall be revealed through the examination of the witnesses and further substantiated by my counsel, Ms. Salsabil Choudhury, in her closing statement. May I proceed to the chief examination of Mr. Russell Ahmed? Okay. Much obliged. Hello, Mr. Ahmed. Please introduce yourself to the tribunal.
My name is Russell Ahmed. I am 51 years old and currently working as the Managing Director of Sino Limited. I have also been the representative of Sino Limited in the deed of agreement and signed the contract on its behalf.
Mr. Ahmed, what can you tell us about the agreement?
Well, on 3rd March 2017, Sino Limited entered into the deed of agreement with Pfizer Real Estate Limited, or we usually call FREL. FREL made an offer to us to develop a commercial building in Dhanmondi, where our registered office building was located. Sino Limited bought the land on 12th January 1996 and built a 6-story building there called FIDReC. However, as per the deed of agreement, we needed to hand them over the vacant land after demolishing the existing building and also provide an irrevocable power of attorney to FREL. In return, FREL would provide us 30 million taka, 60% of the total building of built total commercial space, minimum 24 units of commercial space of the newly built building, and also pay rent of our new temporary office meanwhile. We call this project the FIDReC project.
All right, Mr. Ahmed. Oh, please tell this tribunal what Sino Limited has done as landowner as per the deed of agreement.
We have performed all our obligations under the deed of agreement. Firstly, as per the agreement, we have submitted photocopies of the land title deed and other relevant documents to the respondent on the day we signed the deed of agreement. We provided the power of attorney to the respondent on the same day. Furthermore, Sino Limited was required to hand over the vacant possession of the land to FREL under the deed of agreement, which we did on 19th March 2021.
Thank you, Mr. Ahmed. Mr. Ahmed, why did it take Sino Limited more than 4 years to hand over the vacant land?
You see, our office was located in the previously existing FIDReC complex, and the company was earning approximately 9.1 million taka yearly revenue from the rented out spaces. So we informed the respondent through a letter dated 23rd August 2017 that we would like to start the demolition process of the building only after they received an approval from the Rajuk. And the respondent happily agreed to it. On 23rd October 2019, Mr. Sharek Choudhury, the representative of FREL, informed us that they had finally obtained Rajuk's approval. And after that, we sent out vacant notice to our tenants right away. Within 3 months, the building was vacated and we started demolition process on 1st February 2020. However, due to the COVID-19 situation, the government of Bangladesh declared general holiday and our demolition process came to a halt. Eventually, when the situation got better, we started demolishing from November 2020 once again. And we completed the process on 15 March 2021 and finally handed over the land to the respondent on 19 March.
Understood, Mr. Ahmed. Mr. Ahmed, how did the respondent react when Sino Limited finally handed over possession?
The respondent happily accepted the possession on 19 March 2021. In an email sent on 20 March 2021, the respondent said their project manager, Mr. Talukdar, paid a visit to the site and gave satisfactory feedback. Therefore, they believe that the land was prepared to start the development and they intended to do so as soon as possible.
Okay, that makes sense. So, Mr. Ahmed, what has been done by the respondent, Pfizer Real Estate Limited, under the deed of agreement?
They obtained the approval from Rajuk as per the deed of agreement, paid the rent of our new office for about a year. That's it. That's all they have done. Rather, the list of their non-compliance is quite long. FIDReC was required under the deed of agreement to build a minimum of 12-story commercial building over the land. They all were also required to make payment of 30 million taka under clause 7 of the deed of agreement and arrange and bear the cost of our alternative office accommodation under clause 9 of the deed of agreement. FIDReC to this day has not paid a single penny of the 30 million taka, and 6 months of rent of our alternative office space is still overdue. Furthermore, they were supposed to start the construction within two months from getting the possession of the land, but almost 9 months have passed since 19 March 2021, but they have not started working on the construction yet.
So, Mr. Ahmed, what did Sino Limited do when respondent did not comply with any of their contractual obligations?
We consistently reminded, pleaded, and implored the respondent to comply with their part of the contract. We have sent them letters, emails, noticed over and over again. Sometimes they provided excuses for the delay in the payment under the deed of agreement, but regarding the overdue rent, they did not respond to any of our communications.
But Mr. Ahmed, you have not received a single penny since, well, 10 million should have been paid to you back in 3rd March 2017 while you were signing the contract. Then why did you continue the project?
The respondent kept assuring us that they will surely pay the due amount as soon as possible. Firstly, they requested for an extension of 2 months. Then after the expiration of the 2 months, they asked for another 6 months. And then they said that they will provide it with the second installment. Considering the financial crisis, we have been utmost generous to them in good faith and carried on with the project. You see, we kept on sending them letters, emails, notice, etc. Sino Limited genuinely wanted to complete the project, considering the benefit coming out of it. So we tried our best to not negate the agreement and convince respondent to comply with it.
All right, Mr. Ahmed, what happened after that?
As I said, the respondent have been assuring us from the very beginning that they will pay the due amount to us as soon as possible. However, on 27 July 2021, the respondent sent us an email proposing downward revision of the signing money. We rejected the proposal.
Mr. Ahmed, why did Sino Limited not agree with the proposal of downward revision?
We rejected their proposal because of 3 reasons. Firstly, there was no provision of downward revision in the agreement. Secondly, FIDReC referred to a rehab circular dated 28 June 2021, but the circular only said the developers may discuss and renegotiate financial consideration with the landowner, not revise downwards. So the proposal of downward revision was contradicting with the rehab circular as well. And most importantly, Sino Limited is not a real estate developer, so we are not obliged to abide by or even consider rehab suggestion anyway. Lastly, the respondent has been using the excuse of financial crisis in 2017, which is way before the COVID-19 pandemic even started. Therefore, considering our previous experience with them, we did not see any reason to convince that a downward revision, which was out of the ambit of our agreement, should be accepted anyway.
Mr. Ahmed, so what was the aftermath of the rejection of the proposal of the respondent?
After the rejection of the downward revision of the proposal, the respondent further proposed the reimbursement of the signing money paid till this, but they haven't paid us a single penny of our signing money. So naturally, we reimbursed nothing. Along with that, they asked for commercial conversion fee in the event of failure to accept of the downward revision. But you see, previously existing building, FIDReC complex, was already a commercial building. So the question of commercial building fee does not even arise. Finally, on 23rd July 2021, they sent us a legal notice stating that as we did not agree to the downward revision of the signing money, they decided to abandon the project and also asked us to revoke the power of attorney that we provided well earlier.
Mr. Ahmed, what did Sino Limited do then?
Well, we did want the project to continue, but at the same time, we were afraid that the respondent might abuse the power of attorney and may sell out the land. So we revoked the power of attorney at that time. However, if the tribunal passes a word of continuance of the project, we are very much willing to return the power of attorney to FIDReC in no time.
Understood. Last question, Mr. Ahmed, before coming to the tribunal. Honorable arbitrators, may I go? Honorable arbitrators, may we proceed with the last question?
Yes, I think with the first witness, you end at 4 p.m. So you're about 6 minutes more, right? Would I be right?
Channel, we have to allow a respondent to cross-examine now. In the next.
Oh yeah.
Allow the respondent.
Yeah. Yes. My apologies. The cross-examination was supposed to be set for 10 minutes, and then we are overshot by about quite a bit now, by 5 minutes. 5 minutes. Right.
Okay. So I request now respondent to cross-examine this witness.
Much obliged, honorable members of the tribunal.
Thank you, honorable members of the tribunal. Mr. Russell Ahmed, am I audible?
Yes, you are.
So, Mr. Russell Ahmed, can you hear me? Should I carry on with my cross?
Yes, Counsel, you are audible to me.
Thank you. So, Mr. Russell Ahmed, according to the agreement, the respondent side was under an obligation to pay the first installment after the completion of the handing over of the power of attorney. Am I right?
The respondent had the obligation to pay us for the first installment when we signed the contract.
Okay. So the respondent side did not pay the first installment when the contract was signed, isn't it?
Yes, that is correct.
The respondent side sought 6 months more for the payment of the first installment, isn't it?
Yes, first they requested 2 months, then after the expiration of the 2 months, they requested for another 6 months.
And the claimant side agreed to that, isn't it?
We were more than willing to extend time for them.
Mr. Russell Ahmed, there is no provision in the agreement that allows you to extend the payment of the installment time, isn't it?
There is no provision which is saying that we cannot extend the time for the respondent.
So there is no provision, but since both of the parties mutually agreed to that, so you have accorded that time, isn't it?
Yes.
So in that case, if both the parties agree to a downward revision, that can also be accorded, isn't it?
But in that case, the both parties should agree, right? We didn't agree with them with the downward revision.
So if I may understand, the problem is that both the parties are not at an agreement, but the agreement does allow the downward revision, isn't it?
No, that agreement doesn't allow any downward revision.
So if the agreement does not allow for a downward revision, so it is not allowed, And similarly, I can also say that the extension of the time, that was also not allowed, and you are not supposed to extend that, isn't it?
Counsel, your client claimed downward revision of the payment, showing us
Mr. Russell Ahmed, Mr. Russell Ahmed, let me interfere for just a second. I have just asked you one simple question. Please answer in yes or no. Is it, since you are saying that a downward revision is not allowed, similarly, the extension is also not allowed? Yes or no?
The downward revision was not allowed under the deed of agreement, but there is nothing it said about the extension of the time.
So there is nothing said about the downward revision also. There is no prohibition about the downward revision also, isn't it?
There is no prohibition of downward revision, you are saying, under the deed of agreement?
Yes, that is what I'm implying.
If you see the deed of agreement under the clause 7, your client is to pay us 30 million taka. That is clearly said in the agreement. So why would we allow a downward revision, right? The amount is clearly mentioned there.
The same clause, clause 7, also mentions that the payment should have been done while signing the contract, but that was not done, and you have allowed extension, isn't it?
Well, a project is, it takes a lot of time, right? Your client also had to get approval from Rajuk, and we thought, as we wanted to carry out the project and wanted to do business with your client,
Mr. Russell,
we had been utmost generous to your client. That is all.
Mr. Russell, I just wanted to ask a question. Please answer in yes or no. Yes or no? I haven't received my answer yet. Yes or no?
Do you please repeat the question? I think you should rephrase your question, but I think I have answered the question, right?
Okay, Mr. Russell Ahmed, let's move on to something new. So you have handed over the land on October 2019, isn't it?
We have handed over the land on 19 March 2021.
Okay, 19 month 2000. But the Rajuk approval was on October 2019, isn't it?
Yes, the Rajuk approval was October 2019.
It took you almost 1.5 years to complete the demolition project, the demolition process, isn't it?
I have already mentioned in my examination in chief why it took more than 1 year.
Please correct me if I'm wrong. You have said that it is because due to the government holidays, isn't it?
Yes, it is
due to the COVID-19.
Yes.
So the government holidays created an obstacle in the completion of the work, isn't it?
Yes, it definitely did.
So if the COVID-19 induced holidays can create barriers for your work, it can also create barriers for the work of the respondent, isn't it?
No, we don't believe so, because they should pay us the signing money on 3rd March 2017, right? It is their past performance. It cannot be excused for the COVID-19 situation, which happened on 2020.
Mr. Russell Ahmed, I have not asked you about the signing money. I have said that since you were facing problems in demolishing the project, so the respondent side could also face problems while creating the project, creating a building, isn't it? Just answer in yes or no. Yes or no, just yes or
no. No, we don't think so. Because you actually, the time limit, the timeline you are mentioning, it is not accurate. They in 2021 we handed over them the vacant land, and in 2021 the situation in our country became quite normal, and everybody was going on with their life and their projects.
Since you are saying that the situation was normal, but there has been a second wave of coronavirus, and there was a second government lockdown since the April. You have handed over the project on March, and there was another lockdown from April, isn't it?
Last 2 minutes.
We don't think so. It's not mentioned in the fact.
Honor Mr. Russell Ahmed, you have said this is not mentioned in the fact. This is a very known fact that the government of Bangladesh has imposed a lockdown from April 5th. Are you not aware of the current affairs of Bangladesh?
I am not taking it into my consideration. You should have claimed it in your defense if you believe that you would use it in your case.
Mr. Russell Ahmed, are you not aware of the lockdowns, the timings of you are not aware of the timings of the lockdowns in Bangladesh, isn't it?
I am aware of the timing of the lockdown, which was mentioned in the fact.
So there was no lockdown in Bangladesh since April 5th, isn't it?
Yes.
So the government, so you are trying to say that the government circular that stated that there is a second wave of coronavirus and there is a government holiday from 5th April, you are claiming that the government circular is false, isn't it?
It is not submitted with your statement of defense.
Mr. Russell
On the
Ahmed,
respondent side, you have exhausted your time limit now. Time limit is over for 10 minutes. I request claimant now to examine the second witness.
thank you. Thank you.
Much
Honorable
obliged, Mr.
Chairman.
And I request claimant now please adhere to strictly 10 minutes, not to exceed. Please start.
Honorable Tribunal, am I audible and visible properly?
Yes.
With your due permission, I, the second counsel from the claimant side, would like to chief examine the witness number 2, Mr. Ghulam Kibriya. May I have your permission, Honorable Tribunal?
Yes, you
Thank
have.
you, Honorable Tribunal. Hello, Mr. Kibriya. A very good afternoon. Please introduce yourself to the tribunal.
Hello, my name is Ghulam Kibriya. I am 43 years old, living in Motijhil. I worked as an inspector in Rajuk.
Mr. Kibriya, what are your job responsibilities as an inspector in Rajuk?
My job responsibilities includes inspecting the proposed land areas and buildings in accordance with the plan submitted, check adherence of the construction of the approved building plan, and submitting reports on the basis of that.
Okay. Mr. Kibriya, I have a query that why have you decided to become a witness in this proceeding? Please explain.
It is a part of my official duty to explain the position of Rajuk before the court or tribunal in disputes or cases in which Rajuk has a stake. Hence, accordance with the order received from my higher authorities of Rajuk, I have come before this tribunal to clarify Rajak's action and involvement relating to the dispute.
Duly noted, Mr. Kibriya. Mr. Kibriya, how do you know the parties of this arbitration proceeding?
I came across the Pfizer Real Estate Development Limited back in 2018 as they submitted a design for constructing a 15-story commercial building in Dhanmondi to be approved by Rajuk. But the proposal was returned and FIDReC submitted another design in 2019. The land on which the building was to be developed, owned by the claimant, Sino Limited. As the inspector, I visited the land premise located in Dhanmondi back in 2018 and also in 2019. Recently, the counsel for the claimant approached Rajuk and asked to assist the tribunal regarding the dispute. Hence, as per the order of my higher authorities, I am here.
Thank you so much for explaining precisely, Mr. Kibriya. As you have mentioned in your last statement that the plan was not approved by Rajuk first time, please tell us why did Rajuk not approve the plan initially in the first time?
Actually, there were many errors in the initial plan submitted by FIDReC. For example, one grave mistake was relating to the design of the fire exit. So we had no other options but to return the preliminary plan for modification.
Okay. And when was the plan finally approved by Raju?
They finally submitted the revised plan in June 2019 and eventually we got the approval in the same year to construct the building on 22nd October 2019.
Okay. So, Mr. Kibriya, please tell us, how does Raju give its approval for any plan submitted to?
After receiving any application for approval of any plan, Raju conducts a site inspection of in the concerned area to determine whether the plan should be passed or if any modification to the plan is required.
Mr. Kibriya, What did you see when you visited the proposed plan location at 67 Dhanmondi 1205?
Upon my visitation in 2018, I saw a 6-story commercial building situated in the land with annexed parking facilities in its basement. The building was housing numerous offices, commercial shops, along with Claimant Sino Limited's office. When I visited again in 2019, the situation was unchanged.
All right. So, Mr. Kibria, you are saying that you saw a 6-storied commercial building along with a parking basement situated on the land, and the building therein was also occupied with many offices and shops, including the office of Sino Limited, that means the claimant.
Yes, precisely.
Noted, Mr. Kibria. Now, let's talk about something else.
Please don't ask leading questions here. Don't ask leading questions.
Duly noted, sir. Thank you so much. So, Mr. Kibria, now let's talk about something else. Except for Raju, what are the other authorities needed to provide approval in order to construct a building in the country?
Actually, there are quite a few. You need the approval from Titash for gas lines, DPDC, DESA, DESCO for electric supply, and WASA for water supply. These are the main authorities whose approval you need to construct a residential or commercial building.
Okay. So what about rehab?
Rehab, what about it?
Mr. Kibria, as you are working in this sector concerning the real estate of the country, you may know about the Real Estate and Housing Association of Bangladesh, which is commonly known as rehab. What is its authoritative value?
Oh, yes, I got it now. As per my knowledge, rehab is no authority. So naturally, has no authoritative value. It is mere association for the function of protecting the interest of real estate companies.
Okay, so what happens if Raju and rehab are in a contradictory position regarding a matter?
Well, I cannot think of a situation right now where Raju and rehab will opine against each other, because you see, these are two completely different associations with different nature, function, and scope. However, in a scenario that you have mentioned where Raju's opinion and contradicts with rehab's, Raju's opinion shall prevail, being an authority as long as it comes within the ambit of Raju, as rehab is not an authority anyway.
Thank you so much for explaining, Mr. Kibria. Do you know when a commercial conversion fee is applicable?
It is applicable when a residential building is converted into a commercial building and vice versa. It has to be paid to Raju. However, the amount usually varies from 15 lakh to 50 lakh, considering the location.
But what if the previously existing building was already a commercial building?
Then the equation is simple. If the building is commercial, already in commercial nature, then no conversion is needed, and hence the commercial conversion fee is not required at all.
Oh, very well, understood. Now, Mr. Kibria, how was your experience during the COVID-19 situation in Bangladesh?
It has been a really tough situation for all of us. All institutions were closed for months and most activities came at halt. Construction and demolitions of buildings were no excuse either. Rajuk office was also closed from March till October 2020 and we could not conduct a function meanwhile. The time was really difficult for everyone. Thanks to the Almighty that the horrible situation is over now.
Mr. Kibria, how do you evaluate the situation now?
Now everything is going on smoothly. All sectors, including the construction, health, education, RMG, are functioning like any other normal day, just with health precautions. Rajuk has also restarted their work in full swing, and the construction sector has also restarted its work as well.
Thank you so much. Last question, Mr. Kibria. How far is it possible for a real estate company to construct in present days, as per your opinion?
It is very much possible. I have personally visited more than 18 construction sites this year, and each of them function properly. There is no adverse effect of COVID-19 anymore. The infection rate has dropped even below 1%. The raw materials of construction are being imported on regular basis. So obviously, it is very much possible for the real estate company to start constructing a building right now.
Thank you so much, Mr. Kibriya, for answering the questions as far from your expertise and experience. Honorable Tribunal, no further question from my end. Thank you so much.
Okay, okay. Now I request respondent to cross-examine this witness.
Thank you, Honorable Tribunal. I'm sorry, could you repeat your name, please? Witness number 2. I just missed your name. Thank you, Mr. Ghulam Kibriya. So, Mr. Ghulam Kibriya, you have talked about the approval. So, let me go into that. Are you aware of any you are not aware of any contract between the respondent and claimant side, isn't it?
Yes, that's correct. As I am Rajuk official, I'm not supposed to know that.
But throughout your statement, you have been pinpointing the respondent side for the failure of the design, isn't it?
No, it's not correct, Mr. Counsel. Actually, I made a site inspection. I have just mentioned what I experienced during my site inspection.
If I remember correctly, you said that the design submitted by the FIDReC was full of errors. There were mentioned about a grave error, isn't it?
Yes, they made error and then they corrected it through modification.
Mr. Ghulam Kibriya, under the agreement, it was not FIDReC who was under the obligation to provide the design, isn't it? Are you aware of it?
Mr. Counsel, I'm an official of Rajuk, so I'm not supposed to know about the agreement or anything regarding this. I think
but you have been
counsel could answer this question.
But you have been pinpointing the respondent side for the failure of the design, isn't it?
As they submitted the design for Rajuk approval, that's why I can pinpoint, as there were various application and modification. They applied. They applied for in Rajuk and they submitted the plan in Rajuk. That's why I am just aware of the plan. I am not aware of the agreement.
But under the agreement, it was not the respondent side who are under the obligation to design to provide for the design, and you are not aware of it, isn't it?
Mr. Counsel, I'm not aware of the agreement. I'm only aware of the plan submitted by the respondent side.
Okay, thank you, Mr. Ghulam Kibriya. My next question is that you have talked about the contradiction about the rehab. You have said that rehab does not have any authority. At present, since I won't be asking any question from rehab, because since you're not aware of the rehab's functioning, I will be asking question about the Rajuk. Rajuk has never circulated anything about force measure in Bangladesh, isn't it?
Mr. Counsel, I'm an inspector of Rajuk. My work is limited to site inspection and looking after whether they are following the approved plan. I'm not a high official, so I don't have knowledge regarding this, concrete knowledge regarding this.
But since Rajuk is a sort of like a public authority and the circulars are sought to be of, what should I say, the primary evidence, you as an official should have had the first-hand information about their circulars, isn't it?
Though I don't have any concrete knowledge, but yes, Rajuk did not, as per my knowledge, Rajuk did not publish any circular.
So in that case, till now, there is no contradiction between rehab and Rajuk, isn't it?
And yes, there is no, and I don't think there is any scope, as Rajuk is an authority and rehab is just an association for the purpose of protecting interest of the developers or real estate companies.
Okay,
so it
if
cannot,
I may. Okay, please continue. Please continue.
Also, as it is an association of the developers or real estate companies, it actually cannot bind a landowner or other persons. So it doesn't have that binding effect.
So if I may rephrase your answer, what you're trying to say, that there is no scope for contradiction between rehab and Rajuk, isn't it?
Yes, there is no contradiction.
Okay, Mr. Ghulam Kibriya, you have talked about that the situation is very good now. There is a regular import from foreign countries of raw materials. You are not aware of the recent Bangladesh budget, isn't it?
I cannot I cannot actually state the exact statistics to you now.
You are not aware of the fact that the price of the raw materials for construction has increased after the recent budget, isn't it?
No, I'm not actually aware of this.
So what you have talked about the import is totally a speculation, isn't it?
I haven't. The import export is going on. It has been normal. However, the price the price may have risen, but the import export is has not stopped after the impact of the COVID-19 rate has spread rate has decreased. The import export hasn't stopped.
Mr. Ghulam Kibriya, by any chance, are you denying that there isn't, I think that you are denying that there is a force majeure event in the real estate sector, isn't it?
Honorable Council, I am just an inspector who made site inspection, so I am not aware of this.
But since your expertise is only site inspection, you have already given statement regarding the COVID-19 situation of Bangladesh. You are not an expert on COVID-19 situation, isn't it?
Honorable Council, I am just giving you the information according to as I am making site inspection as I used to do before the case. If I can cite you that from zone 5 of Raju, that is Dhanmondi Lalbagh zone, there has been 546 new application for land use. So my workload hasn't decreased. It is same as it was before COVID-19 break.
Okay, thank you. So during the lockdown period last year, all the works were halted, isn't it?
Can you, sorry, I couldn't follow you.
So I was saying that during the government-induced lockdowns last year, since everything was closed, Raju did not receive any source of, what should I say, any source of application for construction or design, anything like that, isn't it?
Well, only for March to October, which is the lockdown period.
So
after October, Raju started its work.
So you do agree that if there is a lockdown, everything will be halted and Rajuk will also have to stop their work, isn't it?
First, when there was strict lockdown from March to October, then the work was halted. But after that, our regular work started.
There was another round of lockdown this year, isn't it?
Yes, but during this, we had to work.
So you are telling me that last year in lockdowns you did not work, but this year miraculously you worked. Am I right?
Yes, because it was not as strict of a lockdown that it was last year. You know, the last year COVID cases were mass in number, but this year the situation is under control.
Mr. Ghulam Kibriya, going back to one of your answers, you were saying that you are not an expert on COVID-19 situation. Let me just give you one information that the number of death tolls and the number of infections were higher this year. You are not aware of that, isn't it?
But my workload in construction hasn't decreased anyhow, because you know, people are bound to go for work. Though the cases have increased, but people have no other choices. So construction work has already started after the October 2020.
So the government circular said that people are not allowed to go to work, but you want to say that the people should go to work, isn't it? Is that what you are trying to say?
Government holidays were extended for not in a row, but they declared holiday, extended it, but it was not in a row. That it happened in October to the previous lockdown, like March to October.
Okay, Mr. Ghulam Kibriya, I will just ask you one last question. So just for a second, just for a moment, just forget that you are Mr. Ghulam Kibriya, that you work for Raj. Just for a moment. Just assume that you are just a normal citizen of Bangladesh. You have a family. I guess you do have a family. You have kids and you have a family. and there is the COVID-19 situation. Everything is closed. There is a government-induced lockdown. Everything is closed. The infection rates are higher. There is no vaccination, or even if there is a vaccination, it is not working properly because the death toll is rising every day. At that situation, an ordinary person will not be thinking about booking for an apartment, isn't it? Do you agree with me?
I think it was back in the first lockdown where our regular activities has stopped.
Mr. Ghulam Kibriya,
people do have limitations because in Bangladesh during the lockdown.
Mr. Ghulam Kibriya, please let me interfere for a second. I'm just asking a simple question. Just answer me in yes or no. That in that situation, an ordinary person will not think about booking for an apartment or a flat, isn't it? Just a yes no question. Just yes no. Don't
the
since you are
demand
not
supply may differ. The demand or the supply may differ, but it's not true that the ordinary person will not at all, because you know the people who have a fixed salary, they can go for buying an income because their salary were coming. People who are day laborer, day-to-day income, they had a problem. But people who get fixed salary, for government officials, private officials who had a fixed salary, they would not have problem in buying flats, according to my opinion.
So in your opinion, only a certain class of people will be allowed for the apartments, isn't it?
You know, in Bangladesh, so those who have money, obviously, they will try to buy apartments, and they are the customers. So when you are making a survey, so you will make according to your estimated customers, not the whole population.
Thank you, Mr. Ghulam Kibriya. No more questions.
Thank you. Awesome.
I request now the respondent to start the opening statement, please.
Thank you, honorable members of the tribunal. Honorable members of the tribunal, in this dispute today, both the parties are victims of the circumstances. We do acknowledge the sufferings faced by the claimant side, but we reject the contention that we are liable for the breach of the agreement. Honorable members of the tribunal, since the claimant side had already talked about the facts of the dispute, we will just provide a brief summary from the respondent's point of view. The claimant, Sino Limited, and the respondent, Pfizer Real Estate, signed an agreement for the development of a project named FIDReC in the land provided by the claimant on 3rd March 2017. But the land was handed to us on 19th March 2021. Honorable Tribunal, you are already aware of the COVID-19 pandemic and its impact on human lives and the economy. In Bangladesh, there was a prolonged government holiday starting from the 26th March 2020. Though these holidays were lifted after a few months, soon after the handover of the land, there was an alarming rise in the COVID-19 infections, which greatly hindered the real estate sector once again. And in a final decisive blow to the business, the government announced further national lockdown from 5th April 2021. The second round of the lockdowns made it quite impossible for the respondent to recover from the impact of the pandemic. Honorable members of the tribunal, just like a milking stool, our case lies on 3 contentions. Our first contention is that although the agreement signed by both the parties was valid, but due to subsequent impossibility, the agreement has become void. This subsequent impossibility has been occasioned due to the existence of a force majeure event, that is the COVID-19 pandemic. According to Section 56, Para 2 of the Contract Act 1872, if a contract to do an act becomes impossible after it was made, it becomes void. In order to invoke this provision, Honorable Tribunal, we must prove, firstly, that the act has become impossible. Secondly, that the impossibility is by reason of some event which the promisor could not prevent. And finally, that the impossibility is not self-induced by the promisor or due to his negligence. Honorable members of the tribunal, REHAB, an association of real estate developers, through a circular dated 28th June, declared that the agreements of the members of the REHAB falls within the purview of force majeure.
Sorry,
and
my
developers-
apologies. Sorry, my apologies. You said you had 3 points. Can you just spell out the 3 points before you go into elaborate on each of the point? Because I'm not sure whether you're now still elaborating on your first point, or are you on your second point or third point? So can you just tell us in a brief sentence what the 3 points are, and then elaborate that, if that's possible?
Thank you, Honorable Member of the Tribunal. My first point is that the agreement has become void due to substantial impossibility. Secondly, that due to the subsequent impossibility, we are under a right to provide for the downgrade revision of the signing money. And lastly, that in case both the parties refuse to the downward revision of the signing money, the contract will stay void, and thus we are bound to be restored of the benefits that we have provided to the other side. Honorable Member of the Tribunal, if you are satisfied, I would like to proceed with my first contention.
Yes, please. Yes, please. Thank you. That's much clearer. Thank you.
So as I was saying, Honorable Members of the Tribunal, Rehab, an association of real estate developers, through a circular dated 28th June, declared that the agreements of all the members of the Rehab falls within the purview of force majeure, and developers may renegotiate the financial consideration and project completion duration with the landowners. Being a member of the Rehab, we are relying on this circular, which is effective from 1st April 2020. The declaration of the holidays or lockdown by the government of Bangladesh and subsequent circular of the Rehab operates as an official and formal declaration of the existence of a force majeure event. The claimant may...
Sorry, apologies. Can you show us, you said you're a member of the Rehab. Show us that provision and the fact that it is made known to the claimant. Thank you.
Can I get a few seconds to just look into the fact?
No worries. Thank you.
Honorable Tribunal, in the case for the final, in the fifth para, there has been clearly stated that we are imposing Rehab circular notification dated 28th June 2021 on claimant. Honorable Tribunal, should I proceed?
Yeah, go ahead.
So as I was saying, Honorable Members of the Tribunal, the claimant may, in our neighboring country, India, the Ministry of Road Transport and Highways have issued a similar circular identifying COVID-19 as a force majeure event and have relied on a similar circular issued by the Ministry of Finance. The reasonability of this circular has been contested and confirmed by the High Court of Delhi in MEP Infrastructures Developers Limited versus South Delhi Municipal Corporation. The court stated, and I quote, due to the force majeure event, the ground realities had substantially been altered and have unequivocally identified the COVID-19 pandemic as being destructive of the contractual status quo. Honorable Members of the Tribunal, the COVID-19 has directly made the performance of the obligations under the contract impossible because the methods for procuring the fund to develop and construct in the land have been contemplated by the parties in the agreement itself. Clause 5 of the agreement states that the respondent shall market, promote, and offer for sale their share of the project. And further, clause 19 of the agreement states that the respondent shall have the right to mortgage their parts in order to achieve a loan from the bank or financial institution. And these mechanisms these mechanisms of arranging funds were contemplated and approved by the parties in the agreement itself at the time of signing. None of these mechanisms, Honorable Tribunal, were possible to be utilized by the respondent for threefold reason. Firstly, due to the delay in handing over the land by the claimant, which they warrant was due to the government lockdowns. Secondly, due to the lockdowns and prolonged closures, it was not possible to raise funds. And finally, Due to the delay in handing over the land, the respondent were faced with another set of government holidays starting from the 5th April 2017. Honorable Tribunal, in Ferreira Buzzeni SPA versus the Commission of the European Communities, the court has ruled that the impossibility does not need to be absolute. Rather, ability to perform the obligations. Therefore, honorable members of the tribunal, we present before tribunal.
Sorry, we lost you. We lost you just there when you said that the case law says that it's not the impossibility is not necessarily to be absolute, right? Can you just carry on from there?
Honorable members of the tribunal, I was stating that in the case Ferreira Buzzeni SPA versus the European Communities, the court has ruled that the impossibility does not need to be absolute. Rather, abnormal difficulties will also suffice as impossibility to perform the obligations. Honorable members of the tribunal, now I would like to present our second contention, which is that the proposal for downward revision of the signing money was valid.
I apologize to intervene in between. Your time is over, Mr. Counsel. Please allow please allow your first witness to be chief examined. You can conclude your contention in your arguments.
Okay, thank you, honorable members of the tribunal. I would like to call my co-counsel for examination of our first witness.
Yes.
With the permission of the tribunal, I would like to call upon our first witness.
Yes, please carry on.
Much obliged. Please state your name and designation for the record. Mr. Sariq Chaudhary.
Sorry. My name is Sariq Chaudhary. I am the chairman of the FIDReC Real Estate Limited. I oversee all the contracts and negotiations on behalf of the company.
Mr. Chaudhary, when did you enter into the deed of agreement with the claimant?
3rd March 2017.
Okay. Please tell the tribunal what is the purpose of making this agreement.
We, the FIDReC Real Estate Company, had the task of developing a commercial building at the premise of FIDReC complex. Our job was to market and offer for sale of the shares. The landowners shall be entitled to 60% shares of the commercial spaces, and FIDReC shall be authorized to sell to prospective purchasers the remaining 40% shares.
When did the amount of signing money agree to be paid by the respondent?
$10 million was supposed to be paid right after signing the agreement as per clause 7 of the deed, but we agreed mutually to pay it right after handing over the possession of the vacant land by the claimant. I mean, right after we get the possession of the land. That means $10 million was supposed to be paid right after we get the possession of the land. So, but they didn't give us the possession in time, and it really hampered us, and we couldn't pay the installments.
So, Mr. Chaudhary, what losses the delay resulted in regarding handing over the possession for you?
First of all, claimant didn't hand us over the possession for like 1.5 years. I mean, which was supposed to be given to us within 2 months or 3 months. They didn't give us the possession for 1.5 years. And they gave us the possession on 19 March 2021. Clause 1 of the agreement states that the respondent shall develop and construct in the land through own arranged funds or funds from prospective purchasers. But we couldn't manage our funds, nor we couldn't find prospective purchasers because they failed to give us the possession of the land for 1.5 years. And when they gave the possession of the land to us, COVID hit again in the country. So it really caused us very difficult, lots of difficulties.
So what did happen when Raju provided approval for the project?
Raju gave approval of the project on 22nd October 2019. And but what happened was that the claimant took 5 months to initiate the demolition process. They didn't pull a single brick, and they showed grounds that COVID-19 restrictions were imposed by the government. So claimant was unable to give us the vacant land, and for that because they couldn't complete the demolition within time. So it was a very grave negligence on their part.
What did the agreement stipulate regarding the force majeure event?
Yes, clause 29 of the agreement specifically states that both the parties can take necessary steps in the existence of a force majeure event. What do we know about force majeure event? Force majeure event is an act of nature which is unforeseeable and unpreventable. COVID-19, by all sense, is a force majeure event.
What did you do when the force majeure event happened?
We requested for a downward revision of the signing money, but they didn't comply to our request. Rather, they requested their own demands. They told us that, look, we are going to give you some time for paying us the installment money, but we cannot revise the signing money. So if they won't revise the signing money, it will be impossible for us to fulfill the contracts. Because as per clause 29, we are empowered to make necessary arrangements in the existence of force majeure. They already delayed for like 1.5 years to give us the possession. Also, the pandemic came, so how can we do our business if the signing money is not revised? Downward revision is not made by them.
What happened to the rental payment that is to be paid to Summit Association?
We couldn't pay the rental payments because the agreement was void starting from April 2021 due to force majeure event that caused supervening impossibility of the project. So respondent was we were under no obligation to pay for the rent of the office premises to the Summit Association. However, for the rents that were paid, claimant is liable to restore the rent of the office premise for April and May.
How force majeure affects the real estate sector?
Force majeure definitely affects the real estate sector because everything went standstill because government imposed a harsh restriction due to the COVID, and every business got hampered because of that, because every business in the country was standstill. So in this regard, the real estate business suffered severely, and that is why Rehab gave a circular which stated that, look, COVID-19 is a force majeure event, and for that very reason, you all got hampered, your business got hampered, and due to that, we believe that all the developers can renegotiate their financial terms.
So, Mr. Chaudhary, what measures did you take to settle the dispute?
As a respondent, we sent a legal notice on 16 August 2021, and we gave them 15 days to amicably settle the dispute. However, they didn't reply us. They failed to give us any sort of response. So yeah, that is why we are here today.
Thank you, Mr. Chaudhary. No more questions, Honorable Arbitrator.
Honorable arbitrators, it is 4:42. So may I please proceed with the cross-examination of respondent witness 1?
Please proceed.
Much obliged. So, Mr. Chaudhary, how are you doing today?
I'm doing fine. How are you doing?
I'm fine as well, thank you. So you see, you just said in your examination in chief that as per clause 7 of the agreement, you were supposed to pay 30 million Dhaka as the signing money to the claimant, right?
Yes.
But you have not paid a single penny till date. For whatever reason, you just haven't, right?
No. There was reason because they didn't give us
exactly.
the position.
You have
and
stated
also
the
the
reason.
pandemic. Yes, yes,
Yes. Yeah, you have stated the reason in your chief examination. So let me ask you a question that you say that in your examination in chief that the claimant was supposed to hand over the possession within 2 to 3 months. What is the source? Where is it written?
It was actually mutually agreed that they had to pay us the installment fee right after we get the possession. So I stated that when we get the possession, we would pay the installment fees.
No, that was
Honorable Tribunal, we have a slight objection that the previous question was non-leading.
May I rephrase the question, Honorable Tribunal?
Yes.
No, sorry. What is the concern? She's cross-examining, right?
What was the question, Ms. Chaudhary?
Yeah. What was the question? And it's cross-examination. Remember that we're in cross-examination and not in examination. So what is the question again?
Honorable Tribunal, I would like to rephrase the question and ask the witness that what is the source?
Don't rephrase. What was the question you asked earlier in exact words?
Exactly. The question was, what is the source of saying that the claimant was supposed to hand over the possession within 2 to 3 months? I was just asking about the source.
There's no objection in that question. You can ask that question.
Yeah, exactly.
Mr. Witness, you have said that it has been mutually agreed between the parties. So you have added a lot of exhibits. Yeah.
Yes. Sorry. Yes. Please continue.
Okay.
I'm gonna state later.
So then again, just get my question first. I am asking that you said in your examination in chief that the claimant was supposed to hand over the vacant possession of the land within 2 to 3 months. Now, this do you have any source to show that?
No. It was an estimation, but
it was an estimation. So you currently you do not have any proof, and it was not written in the deed of agreement, right?
It was an estimation because before the Rajuk approval, we need to get the possession. Otherwise, we couldn't start the project.
I get it. I totally get it. So regarding the possession, you say that the claimant took more than 1.5 years, and you have objections again regarding this.
Yes.
Why did you know? I mean, you did not raise any objection, right, regarding that?
We raised objections. Actually.
Could you please refer to any exhibit?
We actually told them that we contacted with them through phones.
On the other hand,
orally, yes.
Okay.
Yes,
on the other hand, I think you are contradicting yourself a bit. Please allow me to share my screen.
Okay.
The host has disabled the participant screen sharing. May I have the permission of the host to start sharing my screen again?
Yes.
Okay. So, Mr. Chaudhary, can you see my screen right now?
Yes, I'm able to see.
Okay. So, in your Exhibit 10 of the request for arbitration, response to the request for arbitration, you have stated that with regard, I inform you that FIDReC Real Estate Limited received your vacant schedule land yesterday. Furthermore, our project manager, Mr. Humayun Talukdar, paid a visit to the site and gave satisfactory feedback. Therefore, we believe the land is prepared for development. We intend to do it as soon as possible. So if you have any problem, you did not raise it here, right? You said you got a satisfactory feedback.
Learned Counsel, I was telling that we couldn't raise the funds because you actually gave the land and you delayed to give us the land, right? We told with regard to the condition of the land, we didn't tell that, look, you have given us the land in delay. We just told that the condition of the land is okay and we received it. And that is why we gave a satisfactory feedback. But
let me ask you the question one more time.
Yes,
Land Counsel. You said you have an objection regarding the 1.5 year delay by the claimant, but you have not communicated ever that you were taking 1.5 years. I have problems with that ever to the claimant. You have not communicated, did you?
No, we didn't communicate about this matter. But
exactly,
the thing was
that would answer the question. That's it. Let's move on and ask you something else. During the opening and also the examination of the claimant witness, the counsel for the respondent repeatedly talked about the April 5 lockdown. So it was a 7-day lockdown. Is that right?
I forgot the time of I forgot the timings.
Okay, so it was a 7-day lockdown. It was a soft lockdown, but regardless, if you thought that the lockdown made it really difficult or impossible for you to perform the obligations under the deed of agreement, have you communicated this to the claimant?
As I can remember, the lockdown was extended. As I can remember, the lockdown was extended. If I'm not wrong, I'm refreshing my mind, but it was extended, and I'm pretty sure of it. But the lockdown was extended by the government. If we look at the government circulars, we would find that the lockdown was actually extended, and due to that extension period, we couldn't start the project actually, and also the claimant failed to deliver us the land. So if we both join the arguments, it would be sufficient for everyone to know.
I'm not right now interested in that explanation. So if you could please answer with yes or no, that just tell me this. Is the lockdown imposed on 5 April 2021 is still ongoing?
It's not still ongoing.
Okay.
Yes, yeah.
So let's move on and ask you another question that you said during your examination in chief that you want the compensation back for the rent you have paid in the month of April and May. Did I get you correctly?
Yes, you got me correctly.
Okay. So if I refer to the deed of agreement, I can see that it says under Article 30, Clause 36A of the deed of agreement that if you abandon the project, you lose your chance to be compensated for any of the cost incurred by you. Am I reading this correctly?
Land Council, at first I would like to say that it was the case was about supervening impossibility, that it was made impossible because of the COVID-19, because of the force majeure event, right? Okay. So that is a totally different case.
Let's talk about the force majeure event right now.
Okay.
So as per clause 29 of the deed of agreement, in the event the completion period of the construction of the project being affected by unavoidable circumstances like force majeure, the matter shall be discussed between the two parties and be resolved amicably. Did I read it correct?
Yes, you did it correct.
Okay. But the amicable settlement was failed due to the non-cooperation of the respondent. It has been clearly stated in page number 2 of the case for final. Am I correct? The amicable settlement failed because you did not cooperate.
Sorry. Now we cooperated. We even sent a legal notice that you should come for an amicable settlement, but you didn't comply to our request.
So
let me state the date. Please. Please, I'm going to state the particular date. We, the respondent, sent a legal notice on 16 August 2021. The timing was the 16 August 2021. To the claimant, we gave them a notice of 15 days to amicably settle the dispute, but that we didn't comply to our request, and that is why we are here today, right?
I would like to differ with you on that situation because let me share my screen one more time. Can you see my screen now? Can you see my screen now?
Yes.
Okay, so you see this highlighted portion. Amicable settlement has failed because respondent did not cooperate all this time. Did I read it correct?
Yes, here it is here written that we didn't
exactly.
comply.
So
but
now if you are saying that you cooperated, you are contradicting the established fact established in the case for final given by BIAC. Am I right?
Actually, we didn't agree to your terms, and that is why we didn't cooperate. We didn't cooperate on the
You did
terms.
not cooperate. That's the bottom line.
We didn't cooperate with regard to the terms actually, but not with regard to the matter you are insisting right now.
Yes, Mr. Chaudhary, the time sorry to intervene. The time is over now.
May I ask just the last question to the witness with your permission?
Permitted.
So the last question to you is the downward revision provision. It was not mentioned in the rehab circular, was it?
Now, actually, as per the deed, clause 29, we can ask for downward provision, but it was mentioned in the rehab circular in a different way. They mentioned about renegotiation of the renegotiation of the financial considerations.
If I read the line for you, that rehab has asked developers to
he has given the answer, Mr. Chaudhary. No need to ask again. No need to ask again. He has given the answer. Okay.
Much obliged.
Now I request the claimants to start the arguments and submissions, please. The claimant's time start now.
Honorable Arbitrator, I believe there is one more witness on behalf
Second
of
witness.
the respondent.
No, but 10 minutes have exhausted, Madam Chaudhary. Your time
Wait,
is
no,
over.
the second witness, sir. We are at 4:50 now, and we
Okay,
have.
okay, I'm sorry. There is a second witness. I'm sorry. Exactly.
No, thank you.
Exactly. I got it. Yes. Start with second witness.
With the permission of the tribunal, I would like to call upon our second witness. Please state your name and designation for the record.
Am I audible?
Yes, you are. Please state your name and designation.
My name is Akib Ahmed, and currently I'm working as a regulating member of REHAB.
Mr. Tahmid, can you tell the tribunal that what kind of entity REHAB is?
REHAB is an association that deals with the issues for fostering and protecting, safeguarding the commercial and industrial interest of the members engaged in the real estate development and housing industry, and moreover to promote the idea of amity and trust and cooperation, and to play an active role in formulation of policies in the commercial industries and real estate development.
What are the objectives that REHAB deal with to obtain?
The objectives that REHAB deal to obtain to provide a collective platform for promotion of products and services of the members by organizing real estates and housing fairs both at home and abroad, and to provide a forum for out-of-court settlement and disputes, and to provide a forum for research, study, and discussion of issues relating to real estate and the housing industry, and the dissemination of relevant information with a view to enhancing awareness among members, professionals, policymakers, and general public.
What is the purpose of REHAB circular?
Hope that you're going to make a connection of the REHAB circular that was that deals with the application of force majeure with regard to COVID-19.
When did REHAB circular become effective?
It was effective from the circular became effective from the 1st of April 2022, 13th of September 2022.
What is the perspective of identifying COVID-19 as a force majeure event in the real estate sector?
I just would like to draw that force majeure is an extraordinary circumstances which could not have been foreseen or guarded against. And the force majeure occurrence might impede or obstruct the performance of the contract of either party. The intention of having a force majeure clause in any contract is to save the performing party from the consequences of anything. So as the global economy and due to the coronavirus, from the perspective of the global economy, the coronavirus outbreak has disrupted supply chains, threatened the position of international companies, and dampened the global economic activity. So through the full impact is yet to be determined. That outbreak is certainly causing economic uncertainties. And from the perspective of the uncertainties, frustration, and the unforeseeable being the event of COVID-19 and its outbreak being unforeseeable, so we draw the issues of COVID-19 and its application within the purview of force majeure.
What is your opinion about that COVID-19 affects the real estate sector?
COVID-19 has, of course, affected the real estate sectors, because for companies who deals with real estate sectors following by the contractual obligations are obstructed by this outbreak, and they are left wondering whether the coronavirus can be considered as a matter of development to their interest or not, and that would allow them to delay or terminate their binding contractual obligations. And to answer that, I just would like to agree I would like to stand in agreement with this opinion that COVID-19 has, of course, affected the real estate sectors.
How did the circular of rehab become binding upon the respondent?
We have known that respondent is a party to the rehab, and we know, for your kind information, rehab members being a member to the rehab, they are on a binding position to follow the circular. So violation of that is a matter of code of business, and violation of the code of business of conduct by any member of rehab shall be considered to be a prejudicial and detrimental to the interest of the real estate sectors. And the association, the executive committee may issue a show cause to the offending members such notice. So such notice may issue and may specify the application of its binding force on the members. So that is the issue. So that being the in order to prevent the prejudicial, being the interest of the real estate prejudicial and detrimental to the same thereof, the circular has become binding on the respondents, following by its membership to the rehab.
Thank you, Mr. Tahmid. No more questions, Honorable Arbitrator.
All right. That's great. I request now the claimant to cross-examine.
Honorable Arbitrator, am I visible and audible properly?
Yes, please.
Thank you so much. With your due permission, I would like to start the cross-examination of witness 2 of the respondent. Thank you so much. Hello, Mr. Tahmid. A very good afternoon. How are you doing today?
Good afternoon. I'm very fine, and how are you doing?
I'm also very fine. Thank you so much. You said you are a regulating member of rehab, right?
Yes.
But Mr. Tahmid, I'm doubtful about the existence of such a designation at the rehab. If the Honorable Tribunal gives me permission, may I please share my screen for reference?
Yes, please share.
Thank you. Sir, it shows that host disabled participant screen sharing. Would you please grant me the permission?
Yes.
Thank you so much. So, Mr. Tahmid, I think my screen is shared properly, right?
It's not visible yet.
It's not visible yet.
It's visible yet.
Just give me a second. Is it visible now?
Not yet. Yes,
No.
yes. Now it's visible.
Okay, Mr. Tahmid, here I am in the website of Real Estate and Housing Association Rehab. We see here are the board of directors, right? So if we click here, we will find certain designations, which includes the president, vice president. We also have a number of directors over here, right? So again, if I go into this column, we see here are the names of the members. So would you kindly tell me that, I'm very doubtful about the existence of this designation on which you have arrived in this proceeding, that is regulatory member. I'm not finding any such designation in the website of Rehab. Do you have the proof of this designation with you as per Rehab's constitution or website?
Can you please repeat your question, Ms. Noor? Can you please repeat your question, please?
Yes, obviously, sir. Sir, I was just asking Mr. Tahmid whether he can show us the mentioning of this designation of regulatory member as per Rehab's website or constitution. Can he show us?
May I answer? May I proceed with the answer, please?
Yes, Mr. Tahmid.
Regulating member is a member who stands with the connection and issues of the regulation of this association. So the director and the positions that you have designated and demonstrated to me and to the tribunal as well. Also, all of them are regulating member in essence.
Okay. All right, Mr. Tahmid. As there is
the question does not deal with.
Thank you so much, Mr. Tahmid. As we have very time constraint, let me move on to my next question. As I did not find any such designation in the website, that's why I asked you. So, all right, my next question is, Rehab is an association of real estate developers, right?
Yes.
So the laws and guidelines of rehab are applicable only to the real estate companies who are its registered members, right?
Yes.
But you see, Mr. Tamid, my client, that is Sino Limited, is neither a real estate company nor a registered member of rehab. So is rehab applicable to my client?
But it is applicable to the respondent.
It's applicable to the respondent.
And it has been,
Exactly,
and it
Mr.
has been
Tamid.
substantiated as well that the developers and the developers may come to renegotiation of the contract.
Okay, Mr. Tamid, I will come to that portion, Mr. Tamid. Thank you so much. You have admitted that rehab is applicable to the respondent as the respondent is a registered member of rehab. I completely understand. So now, as you have already mentioned,
this is not applicable on the claimant as well.
Okay, Mr. Tamid, we will come to that portion of the rehab circular.
Okay.
Thank you.
Okay.
So now, as you have already mentioned in your chief examination about rehab, that as per its constitution and definition, it was established for the benefits and interests of developers. Am I correct?
Yes. Yes. Yes.
Thank you, Mr. Tamid. So would I be wrong to say that you, as a regulatory member of rehab, you will try your best to protect the interest of the respondent Pfizer Real Estate Limited?
Of course.
Yes, Mr. Tamid, exactly. To the tribunal, I tried to say this thing that as you are a regulatory member of rehab, and whereas rehab is there for protecting the interest of the real estate company, so you will be obviously protect the interest of the respondent here. You will never be a neutral member in this proceeding. So you are not a neutral witness in this proceeding.
Not at all. Being interested and being interested in beneficial to a particular member does not make it disinterested or does not make it biased to others. Being neutral is standing upon zero,
Okay,
not within the plus.
Thank you,
with
Mr.
the minus.
Tamid. Thank you so much. As we have time constraint,
Ms. No, just a quick point. When you're asking the questions, can you not ask multiple questions in one question? Just stick to one question each. Right? Make multiple questions, because if he says yes, is he saying yes to your part 1, part 2, part 3, part 4? We can't make it out. So
sure,
could you
sure.
just,
Duly noted.
I know it's really exciting to being cross-examining the witness, but just take it in your stride and just stick to one question, please.
It's exciting to be cross-examined also.
As well.
Sir, I will obviously, sir, I will try my best, sir. Thank you so much for notifying, sir. Thank you so much. So, Mr. Tamid, getting back, so you are representing an association that was established by definition and its constitution for the benefits and interests of developers, but you are not trying to protect PREL's interest. Is that so?
No, I have not said that, and I have not admitted that. But the first portion of your question is duly admitted.
Okay, interesting. Okay, let's move on. I would like to share my screen again.
Of course.
Mr. Tamid, can you see my screen? Mr. Tamid?
Yes, yes.
Okay, so please let me read out the highlighted portion from the case given by BIAC. That is, respondent also sent a letter dated 4th August 2021 imposing rehab circular notification dated 28 June 2021 on claimant, which states that rehab members' agreements fall within the purview of force majeure and developers may renegotiate the financial consideration and project. Let me finish, Mr. Tamid. Project completion duration with the landowners. So, Mr. Tamid, here I have highlighted that may portion because it means that the renegotiation of financial consideration and project completion duration is not a mandatory obligation. Rather, it may or may not be done at the discretion of the developers. Is that correct?
It is not mandatory, but it is not avoidable as well.
Mr. Tamid, it is not mandatory. I am saying the same thing. It is not
avoidable as well.
Mr. Tamid, the circular directly shows the clause may. So isn't it, yes, isn't it, we can interpret, obviously we can assume that the developers may or may not renegotiate. It is not a mandatory obligation. Am I correct?
The distinction should stand between may and shall, not may or may not.
Interesting. So let's move on to the next question. So as per rehab circular notification, the respondent was not bound to renegotiate. Is that correct?
Not bound to renegotiate. Yes, That may renegotiate.
That may renegotiate, exactly. They were not bound to renegotiate, exactly.
But they may.
They might have. Okay, Mr. Tamit. So, there was no provision suggesting downward revision in the rehab circular. Am I correct?
Downward revision does not deal with the rehab circular and does not deal with the standard of mine being a regulating member of rehab.
Mr. Tamit, I would highly appreciate if you answer in yes or no, because this is a very precise question, that whether there was any provision suggesting downward revision in the rehab circular or not.
Precisely not.
Thank you, Mr. Tamit. Perfect. That's my last question, Mr. Tamit, to you is, if rehab is not mentioned in any agreement as a party, can it intervene as a regulatory body or a third party?
It is not intervening.
Mr. Tamit, I'm not asking you from any particular scenario. I'm just asking you a simple question, that can it, if rehab is not mentioned in the agreement, can it intervene as a regulatory body or a third party? Please answer in yes or no, as we are in the cross-examination.
But that question does not admit any yes or no question. That question needs explanation. Is
okay, Mr.
Because
Tamit,
this is a circular. A circular does not tantamount to be intervene to intervene in any contractual obligation. This is a circular. A circular.
Yes, Mr. Tamit, and the circular was only for the registered members of rehab. Am I correct?
Not for the registered members, but for the registered members and developers as well.
Registered members and developers, exactly, Mr. Tamit. And as I have already said,
both of them.
To both of them, exactly. For being a registered member in rehab, a party needs to be a developer. Am I correct?
No, not at all.
Oh my God.
Contractual obligation stands between the developer and the real estate company. And you have already said that may negotiate. So we have drawn the issues and the matters from the developers as well.
Exactly, Mr. Tamit.
I am saying the connection between the real estate company and the developers.
No, Mr. Tamit, I'm not denying. I'm just saying that rehab is as from your chief examination statement as
time limit has exhausted, Ms. Noor.
Okay, sir. I rest my questions here. No further question. Thank you so much.
Okay. Now please start your arguments. Claimant.
Am I audible and visible, Honorable Arbitrators?
And I request both the parties to please take 9 minutes for arguments and submissions and 1 minute for rebuttal. 1 minute for rebuttal. Okay? I'm giving you 9 minutes for your arguments and I'm keeping 1 minute reserve for your rebuttal. Okay.
Much obliged. May I proceed, Honorable Arbitrator?
Please.
Much obliged. This is Salsabah Chaudhary appearing as the counsel for the claimant, and I shall be presenting the closing statement for 10 minutes.
Please stop for a moment. Please stop for a moment. Is it right, Mr. Anil and Mr. Ho?
Yes, agreed. Agreed totally.
Like
yeah, we agree, sir. Makes perfect sense.
Thank you. Okay, please start.
Much obliged. At the very outset, I would like to summarize the information revealed during the examination of the witnesses. From the chief examination of claimant witness Mr. Rasul Ahmed and Mr. Ghulam Kibriya, it has been established that before this tribunal that the claimant, Sino Limited, has fulfilled their contractual obligations under the deed of agreement, and the delay in handing over the possession of the vacant land was inevitable and justified for the time. Although respondent witness Mr. Shared Chaudhary has alleged the claimant for unnecessary delay, this such of concern was never communicated to the claimant ever before, until last week when we got their response to the statement of claim of ours. So we declined to consider any such claim as to be true or considerable. From the cross-examination of the respondent witness Mr. Shared Chaudhary and Mr. Akib Ahmed, it has been established that the respondent has not performed their obligation for whatever reasons under the deed of agreement. Now, before proceeding to the issues, I would like to rebut one important claim made by the respondent in their written submission, which is that the rehab circular was of binding nature and suggested that the claimant, although not a real estate developer, should abide by the rehab circular and agree to downward revision. The claimant strongly refuses to agree to such proposition and most humbly submits that the rehab circular is not binding and the claimant has no obligation to renegotiate the financial consideration. We have 3 key arguments in this regard. Firstly, rehab is not an authority nor a regulatory body of the real estate sector, rather a mere association of real estate developers. This is an established fact as per page 1 of the case for final provided by BIAC, where association means the union of persons for the transaction of designated affairs or the attainment of some common object. On the other hand, authority means and includes city corporation, municipality, cantonment board, city development authority, as it has been stated in the Real Estate Development and Management Act 2010 in section 2, subsection 3, and also in section 4. Therefore, rehab is not any kind of authority, does not discharge any public duty, and thus its declaration of force majeure is without of any binding effect, as it has been, such a notion has been upheld in the case of Abdul Aziz versus Alappuzha Bar Association, reported in All India Report 1993, Kerala, page 201, and also in Radheshyam versus State of Madhya Pradesh, reported in All India Report 1959, Supreme Court, page 107. It indeed cannot exempt the respondent from its obligation through their optional notification. Secondly, the circular suggests that developers may renegotiate the financial consideration, as it has been agreed by the witness.
Are these judgments, they say that the parties cannot negotiate? I mean, what did you say that about Madhya Pradesh judgment?
We say that when an association does not discharge any public duty, so that would not be considered as an authority, and the declaration of such association will not be binding. That's what we have said. Okay. And as rehab is merely an association and it is not an authority, the declaration of their force majeure clause is not binding upon the parties.
Mr. Chaudhary, I want to ask, was there any time limit for construction, for developing of this as their disk?
I beg your pardon. Could you please repeat the question?
Was there any time limit for development?
Yes. There was no limit for the claimant to hand over the possession. However,
for the development of the land by the respondent.
Exactly. Honorable Arbitration.
Was there any time limit?
Yes. They have to start the construction within 2 months since the handover of possession and complete the project within 51 months.
I can see from the proposition. I can see from proposition that you took 4 years to hand over the possession, more than 4 years.
I beg your pardon, your Honorable Chair, but
you
we would like to differ.
Why do you beg pardon? Why? I mean,
because I would like to respectfully,
you beg pardon to other parties. Why? Okay.
I would like to respectfully differ with you on this point that it has been agreed by both the parties.
Wasn't there any delay? Was there? I mean, you took 4.5 years to hand over the possession. Is there any wrong thing in that I'm saying?
No, it is not wrong because it was justified and agreed by the parties.
And I'm not saying that I've not asked the reasons from you as yet.
Yes, there was a delay.
What were the reasons, by the way?
The reason was it was agreed by the parties that as there was already a 6-storied building and we were earning revenue from that building, we will only start demolishing after the respondent gets the permission or the approval from the Raj. It has been agreed by both the parties. They got it in 2019, at the end of 2019. So within 3 months, when we gave away the vacation notice, we started our project on 1st February. But as there was a nationwide lockdown from March 2020, we had to stop our project. And then at the earliest opportunity in November 2020, we again started, and within 5 months, we have completed demolishing a 6-storied commercial building along with the basement.
So you are looking at the lockdown with two different aspects. One in your favor and other not. I mean, other at the loss of the respondent. You are looking at the lockdown. You are saying that you delayed in handing over the possession because of the lockdown, but you're not listening to the the aspects of the contention of the respondent that they could not make the payment due to the lockdown.
I have twofold answers to your question.
Effect of lockdown on them also.
May I answer your question now, yes. Honorable Arbitrator?
Yes.
I have twofold answers to your question.
Yes.
Firstly, the reason why we were looking to these 2 lockdowns from a different spectrum, because the first lockdown was longer and more serious. That was a stricter lockdown. On the other hand, if we look at the second lockdown that was imposed in April 2021, that has been referred by the respondent, it was a soft lockdown and only continued for weeks, not months. So now we are very much willing, as you have seen in the case for final, we are very much willing to give them more time beyond the 51 months. All we are asking for this project to continue. And what we have only denied is that the revision the downward revision of the payment, as you can see, Honorable Arbitrator, the payment was firstly due in 2017 during the signing of the money. We have been utmost considerate to the respondent to give the 20 million when we hand over the possession, but they did not, although they said that they would in Exhibit 10 of their submission. And finally, although they have repeatedly assured us, now they have failed to pay us our due payment before the lockdown and after the lockdown. So at this point, we see no reason to be considerate anymore. But regarding the duration, we are very much considerate and we would like to renegotiate on the duration of the completion of the project.
So,
may I proceed?
Yes.
Much obliged. So under the first issue from the case for final statement of claim and examination of witness, it has been evident that the claimant has fulfilled their obligation under the DDAC agreement while the respondent has not. And under the second issue, it has been argued by my co-counsel in the opening statement that the deed of agreement is a valid and binding agreement and it has not become void. Now, under the third,
come to third aspect. Under
the third issue, the counsel for the claimant humbly submits that the acts and omissions on behalf of the respondent contradicting the provisions of the deed of agreement are not justified and amounts to breach of contract. As you can see, Honorable Arbitrators, the only thing we did not agree to was the downward revision of the signing money, which was not provided in the agreement. And it was not also mentioned in the rehab circular, which the respondent was referring to. So we had no obligation, and considering the previous experience with the respondent regarding the payment, we have decided to not agree with that.
Mr. Chaudhary, rehab is a government institution?
No.
What is then rehab members? What is rehab? I mean, this is an association between the developers' interests.
Exactly, only the developers themselves.
Okay.
So, Honorable Arbitrator, the force measure which has been claimed by
it doesn't have any sanction of government.
No.
Okay.
There was no sanction of the government, and as we maintain that Bangladesh, the government of Bangladesh has not declared, unlike India, Bangladesh government has not declared COVID-19 pandemic as a force measure clause. So when there is a contradiction between the declaration of Bangladesh government and the declaration of a non-government organization, which is not even an authority like rehab.
I'm again asking you a question. Rehab has not been recognized by the government.
It has been recognized by the government, but it is not a governmental organization considering its function and its office.
What do you say what do we mean to say that government has recognized rehab?
It means that this is an association which has been recognized, means the government has recognized that such an association can exist and continue their activities to protect and promote the interest of the real estate developers. That's it.
Then does not their clauses, their circulars are binding upon you also?
No, the circular is not binding upon claimant, as claimant is not a real estate
developer. Which was applicable from 1st April 2020 to 30th September 2022, which mentions landowners also. Was not it binding upon you also?
No, Honorable Arbitrator, we have maintained that it is not binding upon us for a few reasons. If you want me to touch upon those points one more time, I can do it.
No, you carry forward with your own contentions.
Just to summarily answer your question, such consideration, such impact of such consideration that may renegotiate is not mandatory, and that is why the parties have, the landowners and also the developers have full freedom to may consider or not may consider. I would just like to move on and refer to the case of Naihati Jute Mills Limited versus Khalia Ram and Satyavrata Ghosh versus Magniram Bangu, where it has been stated that the section 56 of supervening impossibility can only be applicable when it strikes the foundation of the contract and strikes at the root of such a contract. But
please stop. Mr. Anil and Mr. Ho, if you have any question, please ask. Otherwise, I'm asking her to wrap up.
Yeah, I think we need you to wrap up. You know, there were three aspects about that the rehab was not binding. Have you covered all the three aspects?
No, for the time constraint, I have not. Would you?
Yeah, can you just can you do the third one? I think you spoke. You did quite a bit on the first point. The second was the second point a little bit, but the third point on why it's not binding.
It was not binding on the third point because Sino Limited is not a real estate developer, so it falls outside the ambit. And the proposal of downward revision made by the respondent as per rehab circular does not fall within the contractual obligation of the parties. That is why we are not bound by it. May I proceed?
Yeah.
Regarding
May
There
I
was
ask
a breach
Mr. Ho, if you have any question? Otherwise, I'm asking Ms. Chaudhary to wrap up.
Yeah, can we wrap up?
May I ask, how much is the downward revision?
How much is the downward revision?
Sorry?
Mr. Ho is asking that, if I'm right, Mr. Ho is asking that how much is the downward revision here?
Correct. So, since no figure has been given throughout the course of this proceeding so far, so how much was the sum BIAC when we talk about downward revision?
I beg your pardon, Honorable Arbitrator. I did not understand your question at all.
The question was, how much was the downward revision, or what was the purpose of the downward revision?
It has not been mentioned by the respondent when they made the request. However, as we did not agree with it, there is no concrete information on that, as the proposal did not continue.
Okay, then wrap up your arguments now.
Okay,
Next one.
much obliged. According to section 73 of the contract, when a contract has been broken, the other party is entitled to compensation. And according to section 55 of the Specific Relief Act, the claimant is seeking mandatory injunction in this regard. We are referring to the case of Shahzada Muhammad Umar Beg versus Sultan Mahmud Khan, 1970, reported in 22 DLR, page 41. It has been stated that an injunction restraining a person from causing an injury may be mandatory of my mandatory nature. And Honorable Arbitrator, we have already suffered a lot because of the respondent's non-performance. Right now, we are asking for the tribunal to award us with the continuance of the project, as well as the payment of due 30 million Dhaka, which is already overdue, and also the 6 months rate of 6 months rates of 52 lakh 50,000 Dhaka. And Honorable Arbitrators, my clients Unlimited has duly and diligently done what they were required to do by law. So it would be only justified to them, according to the principles of equity and also the principles of law, that after series of legal notices, attempted amicable settlement, and repeated failed attempts to convince FREL to act diligently,
We have read all this. Yeah.
Much obliged, Honorable Tribunal.
Yes,
it has been an honor to submit before it.
May we shift to another counsel, Mr. Anil and Mr. Ho? Okay. Then,
Yes, please.
Yes, Mr. Respondent, please come. Respondent.
Thank you, Honorable Tribunal. Before starting our closing argument, I would like to sum up our opening statement, since we could not cover our last two contentions. Our second contention was that the downgrade revision was allowed by law, by the agreement, and by the conduct of the parties. Because firstly, in the past, we have seen throughout the statements of their witness.
Which part of the agreement allows you? Show us the clause of the agreement.
Honorable Tribunal,
allows you downward revision.
Firstly, I was referring to the conduct of the parties.
No, you started your argument saying that your agreement allows you downwards revision.
Okay,
which part of the agreement? Please show us, refer to the clause.
Honorable Tribunal, the clause 29 has not mentioned anything about prohibition towards downward revision. It has stated that they may negotiate, and the negotiate does not prohibit downward revision. And if you are not convinced with my fact, I would like to point towards the conduct of the parties. As we have seen from the witness of the claimant side, that in the past we have made requests about delaying the payment of the first installment, and they have agreed to that. There is nothing in the agreement that stated that the installment process can be delayed, but they have agreed to that. So in that process, we are of the contention that since in the past they have through their activities has given us the impression that such changes may be possible, we are relying on that. And
Counsel, wait, hang on. You're wrapping up, and you really have to cut to the chase and be sensible about it. Now, delays and an extension of time to pay are things that are caused by arising out of the delays. Just highlighting the fact that it doesn't say you can do a downward. A downward is asking for cheaper price. So how do you justify that in light of the time needed and extension? You haven't crystallized that point. If you can crystallize that point, that we were left in a position that we really couldn't deal with this, and the only way the project could have gone forward is if we got a downward revision and we still would have been able to carry on with the project. So don't go to the technicalities or the legalities of the contract doesn't say this and they say that. Just cut it. Yeah.
I add to Mr. Anil, if we accept your argument that absence of downward revision, that it is not, it is not prohibited, this clause, absence. If we accept your argument, then everything will be applicable, whatever has not been mentioned. And number one. I add second aspect to Mr. Anil's question and Mr. Anil's observations. You say that you are referring to the conduct of the claimant. You say that at the first instance they agreed to your extension of time. Their good conduct now is binding them for accepting your second extension also.
Okay, may I answer your question, Honorable Tribunal?
do answer, please.
Yes, please.
Honorable Tribunal, in my opening statement, I stated that when the parties entered into the agreement, they have contemplated the methods through which the funds will be raised for this project. It is under clause 19 that we have stated that when we can ask for mortgage from the banks. And again, we have stated in another clause that the parties may promote for sale so that we can raise the fund to complete the project. But honorable arbitrators, I would like to emphasize on this point. Since the claimant side has not given us the possession of the land in due time, we could not do any of these activities. You could look into that, because how can we promote for a land that we still don't have any possession? How can we ask for loan for a land which we did not have any possession? And they are stating that due to this coronavirus, due to the lockdowns of the government, they were delayed. So we were saying that due to this lockdowns, they were delayed, and as a result, we could not procure fund in order to complete the project. That is what we are trying to imply, that the coronavirus had caused them to delay, which has resulted in our inaction. That is what I'm trying to say, honorable arbitrators. And if you want to ask me about the law, about a binding law, according to section 62 of the Contract Act 1872, it allows the parties to rescind, alter, or substitute the entire of the contract if the parties agree to that. In that sense, we were right to ask for them for the downward revision. Honorable arbitrators, let's just forget about the coronavirus.
Right, but it would have become applicable to them had they agreed to it.
Honorable arbitrators, as I have stated, that since the methods for procuring the fund is not possible due to this coronavirus pandemic, there is no other way for us to pay for the signing money. Honorable arbitrators, let's
just that. So sorry. So your point is that the ability to procure the necessary monies to carry out the development were hindered as a result of the delays and the coronavirus and the delays and the consequential events that took place. Just that line makes perfect sense to me. It now makes perfect sense to me. So now just quick question. Where is that in your case statement? Where is that in your opening and all of that? Because that line, whenever you use the line downward, it is just a negativity, but you just pinpointed a very critical point. The ability to raise the necessary funds to carry out the project and complete the project has become very difficult because of the COVID-19 and the delays that arose. And part of the delays included the delays by the claimants, right?
Yes, honorable tribunal.
So is it anywhere in your case?
Yes, honorable member of the tribunal, it is in our written submission. And I was coming to this point because, as I stated in the opening, we had three contention. I could only cover one contention. That's why our second contention was that.
Okay, go on. Let's go to the second. Then let's go on to the second contention.
In the third contention, honorable tribunal, we stated that if the parties do not agree to this downward revision, then the contract will become void. Since it is not possible to carry out the obligations, the contract will become void. And according to Section 65 of the Contract Act 1872, if an agreement becomes void, the party which has procured any sorts of benefits under that agreement is bound to restore it. As we have stated that the agreement will be void from 1st April, and we have paid for the rent premises, for the rent of their premises for April and May. That means they are entitled, they are under obligation to reimburse the rent for the month of April and May. And again, there is another clause in the agreement that states that
last minute for your arguments.
Honorable Tribunal, can I just refer to that? Can I just shift to the rebuttal, please? If you allow me.
You summarize your arguments first.
Okay, so we were stating that since we have paid for the rent of 2 months that we were not obliged to pay for, and again that we have already paid for all the fees and governmental taxes for those months, we under Section 65 they are under an obligation to reimburse for that for those amounts, and we are contending on that. And regarding, I would like just shortly touch upon the rehab circular. Honorable Tribunal, we have always stated that the circular was binding upon us. It was not binding upon them, but they have denied the downward revision on the basis of this circular. So this position is totally contradictory. They are saying that this circular is not applicable to them. Again, they are stating that we are relying on this circular itself for denying you the downward revision. This position of the claimant side is totally contradictory. Again, Honorable Tribunal, I would like to say all the damages claimed by them is not allowed under the law.
Done. Mr. Anil, is there any question to be asked by you, or we should?
No, we are done.
Mr. Ho, would you want to ask any question, or we should ask them stop now?
Yeah, no question.
No question. Okay. Okay, Mr. Bashar, I know all your general contention now. We have read your propositions. Now I refer to the claimants counsel to rebut. Last minute, 1 minute to you.
Much obliged. I have 4 points for rebuttal. Firstly, whenever the claimant did something different, it was agreed by both of the parties, and that's how it became applicable. Just because something is not prohibited doesn't mean that it is applicable to both the parties unless they both agree to it. The Respondent Council has referred to Section 62 of the Contract Act of rescission. However, the parties never agreed to it. That is why it is not applicable. Secondly, regarding the difficulties in raising fund, it was also never communicated to the claimant unless and until last week when we received their statement of respondent. Honorable Arbitrator, how can we consider something that has never been communicated to us? The only thing they have talked about is the reduction of the signing money. And based on that, we have declined to the downward revision. Under point 3, they have suggested that the contract, the deed of agreement stands void from 1st April. Again, another information that has never been communicated to the claimant. Rather, even after the contract was void, they went on, they continued their possession of the vacant land as per the deed of agreement, and they have moved on till July, 27 July. Then they have proposed the downward revision again within the scope of the agreement. So this is the self-contradictory position. And may I just touch upon the last point just for 30 seconds?
Okay.
Regarding the reimbursement of the taxes and the rents, the respondent has not submitted anything regarding the tax they paid, so we decline to consider. And to answer the reimbursement as a whole, I would like to refer to clause 36A of the deed of agreement, when it says that in the event of the second party or the developer abandons the project, which they did according to page 2 of the semi-final case, then the abandonment shall forthwith stand for forthwith. The second party developer hereby expressly waives any recourse to recover any such payments on considerations, which is why the claimant is not bound to pay anything as has been paid by the respondent under this deed of agreement, because they themselves are abandoned. Much obliged.
Okay. Now, Mr. Bashar.
Honorable arbitrators, we will touch upon the 4 points presented by the learned friend from the claimant side. First is their contention about that the parties did not agree. Honorable Tribunal, we have never said that the claimant side is bound to agree. We have said that the claimant side should agree, and if they do not, then the contract stands void. That means they are under no obligation to agree to that. But if they don't agree, then the contract is void. That is what the law says. And regarding second point, it's about the communication. We have, if you have paid attention to their first witness in the cross have said that they are not aware of the government lockdowns. Honorable Tribunal, government lockdown is a general knowledge. It is not something special that you have to be a special person to be knowledge of that. Everyone knew about the government lockdowns. It is binding on every entity, every company. It is not something that we have to communicate to them that there is a government lockdown and do you know about that? We have thought that this is a common knowledge that every entity, every citizen should know about the government lockdown. And in regards to the third point of view, I am again referring to my first argument that we were contending that we want this agreement to carry out through downward revision. And if you do not go for downward revision, then it is void under the law. That is what the law says. We are not contending that we want this contract to be void, but if you do not agree, then this is what the law says, that it is void. And regarding taxes, we have mentioned in our claims that we will ask for the money as per the government policies, as per the government receipts. It's not upon us to determine what the taxes of the government is. If the government says the taxes are free, there is no taxes, then they don't have to pay for that. And if the government asks for 1 lakh taka, they have to pay for 1 lakh taka. It is upon the government receipts. And one last point that we would like to present, they are saying that we have denied to perform our obligations. Honorable Tribunal, we have not denied. Rather, it is the situation that has made us incapable of performance of these obligations. Honorable members of the Tribunal, I would like to raise the case. Thank you.
Mr. Anil and Mr. Ho, would you want to ask any question to both the parties, any of the parties?
No questions.
Should we ask them to leave and or
they can move up.
I request Mr. Akmal to
move
shift
up
us
to
in a separate room, Mr. Ho and Mr. Anil and me. Either things you can do.
Before that, we have a dignified speaker. Please listen to him, then you can move.
Okay.
Please.
Ladies and gentlemen, it will take 10 to 15 minutes to prepare our result. During this period, we will hear from our guests. It is a great pleasure for me to introduce our guest of honor, Mr. Masroor Arifin, who is the Managing Director and CEO of the Citibank Limited. Earlier, he was Chief Operating Officer of the bank. During his checkered career of an eminent banker of the country, Mr. Arifin worked for ANZ Greenledge Bank, Bangladesh, Standard Chartered Bank, Qatar, and ANZ Banking Group in Melbourne, Australia. He also served American Express Bank, Bangladesh, Citibank, NA, and Eastern Bank Limited. He completed his master's from the University of Dhaka and MBA from Victoria University, Melbourne, Australia. He is a well-known author and has written several books which have been highly acclaimed by critics of the country. We feel privileged and honored to have him as our guest of honor at the final of the contest. The Citibank Limited is our sponsor. We are delighted to announce that Citibank Limited has shown interest to sponsor this arbitration contest in 2022 and 2023. Now, I would like to request our guest of honor, Mr. Masroor Arifin, to say a few words for our students and audience. Over to you, sir.
Mr. Arifin will be with us in a few minutes. He's having some problems in getting into the system, getting the connection. Yep,
Hello.
there it is.
Hello.
You're on.
Yes, sir. So shall I start?
Yeah, go ahead.
Okay. Now, thank you, sir. Thank you, Rumi Ali, sir, and all other distinguished guests. Sorry that, I'm Mashoor Arifin, the CEO of Citibank. I am at an outside venue, holding bank's business strategy and budget meeting for 2022. And sorry that, I couldn't be here for some more time to enjoy the inter-university, the competition that's been going on today. But I'm very pleased to be the title sponsor of the event. And I see that it's been a few universities who participated, universities from different other countries, from India, from Pakistan, from also Bangladesh's 2 or 3 institutes, 1 university, and finally Dhaka University and Chittagong University, University of Chittagong. They have come up to this far as one as the claimant party, another as a respondent party. But as the CEO of the bank, I'm happy that we are engaged in this process, because I am personally a supporter of arbitration, and which is legally enforceable, and mediation is also in our culture is important. End of the day, we are burdened with 35 lakhs cases, litigations in our courts, where judges are only 1,800 or so. So this tells me that how much role arbitration can play in settling things outside the formal environment of courts, where I as a banker see it this way, that it's an invariable component of commercial trade, commercial growth, and dispute. We are very much into trade business. This year our bank has done a total trade volume of around $7 billion, which is 8% of country's total trade volume. There, and we are also into, like I'm talking from my own experience, we are also into many global level contracts. Only 2 days ago, we have launched country's first digital nano loan with bKash, the global #1 MFS company. There has been underlying contract between us and bKash. So this is just to say that many things can go wrong in the world of economy, in the world of global economy, which is completely transformed by the remarkable growth of trade and other businesses in the last few decades of Bangladesh. So I personally feel that the method of dispute settlement is a great concern especially when we're dealing with foreign investors. I represent IFC in Citibank, which is one of the largest shareholders of the bank is IFC, and also we are the American Express of Bangladesh. But talking about myself, I mean to say that it is important for all others, where among the foreign investors, parties could be uncomfortable and reluctant to settle matters in domestic judiciary system. So there, I believe in terms of impartiality of local courts, they have doubts. I have seen, in terms of, believing in the local administrative bodies, the foreign parties have doubts. So therefore, to gain and keep foreign investors' confidence, we need to seek recourse to ADRs like arbitration. And this is also, timeline is fixed, which is a good thing here. And we'll all know that, our regular courts, as I said before, are overburdened with so many huge, pendency of civil as well as criminal cases. And one last thing I would like to say is that, this disposal of litigations filed in Bangladesh that has happened, as briefed by my head of legal, that dispute of litigations filed in the last century has come to be disposed in the current century in Bangladesh. But in commercial environment, time is money. So I am a firm supporter, as Rumiali sir knows, of arbitration as a mode of settling litigations. And another thing I would like to say that is the importance of a fair, stable, and predictable legal framework for generating inclusive, sustainable, and equitable development, economic growth, and employment, generating investment and facilitating entrepreneurship is definitely undeniable. I'm happy that Bangladesh is part of the 1958 New York Convention, where 162 countries are signatories, including my country. So, and Citibank has already taken a lot of steps towards the right direction, I believe, by embracing arbitration and ADR. And we have executed already an MOU with BIAC, Bangladesh International Arbitration Center, already. And our bank, in almost all of its commercial, local, international contracts, now after they have signed up with BIAC, we are incorporating arbitration clause invariably under institutional supervision as a primary and binding method of dispute resolution. So I believe that this kind of program is enlightening, and I'm sure amongst the students we have seen, I have not seen because I'm busy here, I already told, but I'm sure that you all have seen those who have been competing today. From them we'll see a lot of the legal minds flourishing in the legal arena, especially in the ADR arena in future. So basically from my side, my big thank you to BIAC, and I'm very happy to be part of this, to be title sponsor of this, and this is just the beginning. We have always been with BIAC. We are a great supporter of BIAC, and like in my own bank, there are 4,800 litigations going on. I don't know, like I'm sure the thing that we deal with, the defaulter cases, there we need to go to, there is a need for us to go to formal courts, but that's not all we deal with. As I said, we deal with many other kind of contracts. We deal with many other kind of, the trade disputes and all. So there, I would, in future, I would definitely, I'd be very happy if we can pass on many of our cases for BIAC to settle for us. And I would like to take this opportunity to congratulate the champion and the runner-up teams for the achievements, and I wish all of you very best. And the foreign, chairperson, the judges, Dr. Deepak, and also members, Mr. Anil, Changaroth, and Mr. Meng. My thank you to all of them. And I have also been told that it's not the first year of this international inter-university arbitration contest, but I think it's the first time that international level competition has happened. I think so. I'm not sure, but that's what I have been told. So in future, I'm sure from the neighboring countries, more countries will come and join us, and we'll have more awareness about arbitration and mediation and ADR, and our young arbitrators of today will become a solution providers for all the big corporates like ours tomorrow. Thank you, Rumiali sir, and thank you everyone. Thank you.
Thank you, sir, for your kind words and support to BIAC. Today, we have with us Mr. Mohammad A. Rumiali, who is the Chief Executive Officer of Bangladesh International Arbitration Center, BIAC, since October 2015. Among his many assignments in the past, he was Deputy Governor of Bangladesh Bank, CEO of Standard Chartered Bank, Chairman of BRAC Bank, Founder Chairman of Bikash, the first mobile financial service in Bangladesh. He also served as the Managing Director, Enterprises and Investments of BRAC. Currently, Mr. Ali is the Chairman of AB Bank Limited. I now request Rumi Ali sir to share his feelings on this auspicious occasion. Over to you, sir.
Thank you, Mahbooba. Chairman of BIAC, Mr. Mahbubur Rahman, our guest of honor, Mr. Masroor Arifin, I understand you'll have to run away, but thank you very much, Masroor. Before you run, I have to say this for sponsoring that, and I'm sure we'll see you sponsoring more of our programs in the future. I'd also like to Chairman of the Tribunal, Dr. Deepak Jindal, members of the Arbitration Tribunal, Mr. Anil, Changaroth, and Mr. Meng, the finalists, Dhaka University and Chittagong University teams, and our distinguished audience. I feel honored and privileged to be given this opportunity on behalf of BIAC to speak to you on this very important occasion for BIAC. BIAC is the only institution authorized by the government to specifically promote, facilitate ADR or alternative dispute resolution in the country. One of the areas we have concentrated on is the future legal minds of the country. And to do that, we have in our outreach program, we have actually reached out to the young people who are either in institutions studying or young lawyers. The reason is Bangladesh has lagged behind in accepting institutional ADR. This has had a tremendous cost economically. It has also a negative impact on the global perception of Bangladesh as the preferable place for doing business. As you all know, Bangladesh has trailed in the penultimate position in enforcement of contracts. This has created a negative perception of the country's adherence to the rule of law in our commercial transactions. One of the main issues has been the length of time and the tortuous judicial process that is involved. Experience all over the world has shown that ADR is a global best practice to alleviate this situation. Therefore, the first world countries today increasingly use mediation and arbitration instead of the judicial process to resolve their disputes arising from the contracts. Statistically, I'm told that ADR accounts for more than 90% of the cases. The efficiency and effectiveness of ADR process is not lost on the policymakers, and the laws and regulations of those countries have been progressively reformed to facilitate the settlement of commercial disputes through ADR in these developed countries. From the government's point of view, to create the capacity to handle majority of the commercial disputes in any country will require time and diversion of financial resources away from the more important social and developmental priorities. Although we do have what is called an ad hoc arbitration to resolve commercial disputes, but these are held privately without an institutional governance. It therefore falls short in credibility, accountability, and governance, and cannot be considered as a sustainable process. Ad hoc ADR has a place in the dispute resolution ecosystem, I admit, but it cannot be a sustainable default process. However, the situation on the ground in Bangladesh is very strong resistance from all levels in mainstreaming institutional ADR. The government, even after passing laws, hasn't taken any further steps to reforming the laws and introducing guidelines or facilitating in building a robust ecosystem to encourage the move to ADR. The commercial world in Bangladesh has a persistent embedded view that ADR is neither effective or efficient and does not work. The legal fraternity, I'm afraid, appears at best disinterested or at worst supporting the status quo on institutional ADR. And not even 0.001% of all commercial disputes are referred for resolution through institutional ADR. BIAC believes one way we can change the mindset is by working with our future legal professionals. And with that end in view, we designed a lot of activities in our outreach program. Unfortunately, our financial resources limit us severely in pursuit of this objective. And that is why I would like to express my deep gratitude to Citibank for extending their hand to assist us in this task. I'd particularly like to thank Masroor Arifin, the CEO of Citibank. Masroor has also personally reassured me that Citibank will certainly want to continue this assistance over the years. Masroor, in fact, was a junior colleague in my days at ANZ Greenlands Bank. It has made me proud by living up to the promise he showed as a young banker in the late 90s. We again, once again, thank our co-sponsor, Citibank. I'd like to thank our chairman, Mr. Mahbubur Rahman, for sparing the time to be with us. The members of the and the chair of the tribunal for taking their time. Thank you very much. The finalists, Dhaka and Chittagong universities, I wish you both success. And I also like to thank our distinguished audience on Facebook and our media partner, Bonik Barta's Facebook, and on other media platforms who are with us on the live stream. Before I end, I would like to recall with great pride and deep humility our valiant freedom fighters and countless great young men and women who laid down their lives for our freedom under the leadership of nation, Bangabandhu Sheikh Mujibur Rahman. This month, December, is our Victory Day, and on this month, I'd like to felicitate all of you and also all my countrymen all over the world. With those words, I'd like to leave you all with a great thank you. Thank you very much.
Thank you, sir, for your nice words. It is the time to hear the closing remarks from Mr. Mahbubur Rahman, who is the current and founding chairman of Bangladesh International Arbitration Center. Mr. Rahman is an eminent businessman of the country. He is also the president of International Chamber of Commerce, Bangladesh. He is the only arbitrator from Bangladesh for the China International Economic and Trade Arbitration Commission, CITEC. Mr. Rahman is the chairman of Island Insurance Company Limited, chairman and CEO of ETBL Holding Limited, and chairman of the International Publications Limited, publishers of the Daily Financial Express. He is the only businessman from Bangladesh to be listed in the 150 high impact leaders under the Creating Emerging Market Project 2020 at the Harvard Business School, USA. Over to you, sir.
Before Mahbubur Rahman sir speak, just 1 second, if you allow me. I missed seeing Mahbubur Rahman sir here.
I'm here.
To speak to him. Assalamu alaikum, sir. Sorry, I missed seeing you. And to answer Rumi Ali sir's question on Citibank's participation, I promise, and I already told him this will continue. This is the just first year. This will continue, for years. Thank you.
Thank you very much, Citibank, and you have been our supporters since long, and we have been here and existing for the last 10 years and more because of the support that is being given by the banks and institutions like you. Otherwise, it would have been difficult. Our journey would have been difficult. But nevertheless, I think you have been continuing with your session since 3 p.m. Am I right?
Yes, sir.
From 3 p.m. and now it is 6, more than 3 hours. It is really little tiring, but it is being a concluding session. So naturally, we and you had no choice but to continue with this. And I would not like to take much of your time because many of the points that I would like to raise or the points that issues or the ideas that you have already discussed with these 3 days. And just a formal concluding remarks. Bismillahirrahmanirrahim. Distinguished participants and the Chief Executive of the BIAC and the Chairman of this today's session, and ladies and gentlemen who are joining us and listening to our deliberations. Assalamu alaikum and a very good evening to each one of you. I'm very happy for being with you at this final session of the Citibank BIAC International Inter-University Arbitration Contest 2021. We are particularly proud to have launched the first international arbitration contest, unlike many other contests that was ever held in Bangladesh. I understand 7 universities from home and abroad participated in this contest, and I want to thank each one of them for their participation. I would like to take this opportunity to convey my sincere thanks to Damodaram Sanjeevaya National Law University and Lahore University of Management Sciences for participating in our contest and adding an extra flavor to it. My thanks also to the University of Dhaka, University of Chittagong, BIAC Academy, the London College of Legal Studies, Independent University Bangladesh, and many others who has personally participated in this contest. Primarily, we initiated this event with a view to put forward the concept of international commercial arbitration to our young law students in Bangladesh and beyond. As you all are aware that in this 21st century, a significant number of international commercial disputes are now resolved through mediation and arbitration, which is the practice in many international sphere. But in Bangladesh, somehow this mediation and arbitration did not really took note, though personally some lawyers and eminent retired judges, they practice arbitration and mediation, but did not really have its total ground in this. And for that reason, the BIAC came into being with the support of the trade bodies of Bangladesh, the Dhaka Chamber of Commerce, Metropolitan Chamber of Commerce, and ICC, the International Chamber of Commerce, which you know ICC also maintains the International Court of Arbitration. And so ICC Bangladesh National Committee joined together to popularize what is called arbitration and mediation to support business dispute so that we do not go on joining the court proceedings for years together. So therefore, I must mention here that your support and cooperation in this and joining in this contest, and more particularly the young students who are going to take up their profession in the legal field in days and years to come. And we have organized this for their knowledge and understanding. Primarily, we initiated this event with a view to put forward the concept of international commercial arbitration to our young law students in Bangladesh and beyond. As you all are aware that in this 21st century, a significant number of international commercial disputes are now resolved through mediation and arbitration. It is our view that the upcoming legal professionals should not be deprived of skills and learning that is required to resolve and settle any dispute outside the court. Invariably, arbitration has become a common practice for many to resolve any commercial dispute than any other means that are available before them today. Therefore, we like to take a stance for upcoming legal professionals to learn and characteristics of the arbitration process as to how the parties opt for private dispute resolution in the real world, and to provide an equal opportunity for the students to witness the entire legal process and technical spectrum of the arbitration proceedings that is much needed for them. Consequently, in this contest, all our students were assessed by prominent arbitrators from Pakistan, India, Sri Lanka, Singapore, and Bangladesh. I would like to thank those distinguished practitioners for joining us and supporting us in this process. In a sense, the objective was to provide the students with an opportunity to be assessed by the professional international arbitrators of high eminence and receive constructive feedback in return. We wanted this for our law students so that they can learn from their feedback and in future embark on their legal career with appropriate knowledge, in particular when exploring the avenues of ADR for their clients and when acting as an arbitrator. I'm extremely thankful to all our learned chairmen and members of all the sessions of the contest, and in particular to Dr. Deepak Jindal, chairman of today's tribunal, Mr. Anil Changaroth, Chimba LLC, Singapore, and Mr. Ho Meng, Financial Industry Dispute Resolution Center, Singapore, for the final. Due to catastrophic COVID-19, the event is being held online. However, in the years ahead, we hope to organize such event in person at our premises in Bangladesh. And we would like you to join in those future events. And we would also like to include many others in the process. We are optimistic in this regard. We will continue to organize such contests so that our young students can continue to obtain the prerequisite skills that are required in the legal profession when practicing and exploring the means of ADR, and try their best to embed its norm in their own jurisdictions. I would like to say thank you once again for all your support and participation. I do not really know how many students joined here in the whole contest, and you will be definitely making the final list of those who have championed in this contest. And as I said, we will continue to look forward to your support in days and years to come, and in order to help us to make a deep root for alternative dispute resolution in Bangladesh, because many of us still rely on the court whenever there is a dispute, and we only like to see that the alternative dispute resolution is definitely the option where time and money is saved and business can prosper. Thank you so very much.
Thank you, sir. Yes, sir. Thank you,
Please.
sir, for your valuable words. Now we will watch a video introducing BIAC. Dear all, we are taking a short break for 5 to 7 minutes to give time to our honorable arbitrators to calculate the marks. Please do not sign out from the session, but you can keep the video and audio turned off. We will be back soon with the result.
No, profitability.
We just, the judges are just waiting for our chair to come back on, and then we are ready. We're just waiting for our chair to come back on. We are ready to share our views. We'll just wait for Dr. Deepak. Yes, he is here.
Okay. Mr. Atmal, what is the next thing you do?
Yeah.
Carry on.
Okay.
Dear all, as we have come close to the end of the event, I'm handing over the floor again to the chairman of the tribunal to declare the result along with feedbacks from all members of the tribunals and his own feedbacks.
Okay. Thank you, Ms. Mehbooba. I'll ask my colleagues first, Mr. Anil and Mr. Ho to make their comments. Mr. Anil, please.
So Ho is going to go first.
Anil, go ahead. Mr. Anil,
All right.
go ahead.
Yeah, okay. All right. So you know that both Mr. Ho and I are from Singapore. So we come with certain set guidelines and all that. I must say it was very, very impressive when you guys performed. Right. I say that because when you look at your drafting and the written submissions, that's the first point I want to speak about. I want to speak about 4 points. If you look at your submissions, what you did today was far more superior to how you put your papers together. And some of the basics are these. Both parties, you never numbered your paragraphs. I mean, if you look at your opening statements, you look at your case statements, and if I ask you, your headings have got numberings, but the headings itself being numbered is just a small portion. If I look at any page, if I look at page 3 and the 4th paragraph in page 3, what number is it? There's no numbering, right? And I think one of the parties didn't have their whole case justified. The text was not justified. Now, I know I'm being picky, but you have to appreciate you're asking the judges to look through a whole volume of documentation. And if you don't put it in a very clear, systematic manner, it's really difficult to track and follow, right? So if I look at page 5, the 4th paragraph in page 5, it's not numbered, right? And what you can do is that you just quickly go and Google international dissertations and so on, how they're numbered. You usually have a subject or a title is bold, italic, bold capital text. The topic is just bold text, and the subtopic is bold italic text. So you know what is the main heading, second heading, and then the paragraphs are all numbered. So it's easy to follow, right? The other thing I caught off guard was I didn't realize that the claimants had put all theirs into a bundle, but they call it final arguments. But the point of the matter was that is the bundle of documents for the hearing, and the bundle of documents includes your case statement and so on, but not final arguments. When you said the final arguments, I thought that was just a closing up and all of that. So that's on submissions and then all that. It's really very, very important because it takes up about 15%, to me, it takes up about 15% of the work that you really need to do, 15-20% of the work. If you get all of those things ironed out perfectly in order, then when you're, the next point is about presenting the case, right? When you start off and you present the case, you have to be succinct. You'll notice that I repeatedly ask, hang on a minute, so what are your points? So if you say, my case, our case is 3 points. The 3 points are A, B, and C. Let me now go into point A, and then you go and elaborate. Instead, what you did is that you went, I have 3 points, point A, and then you went on and on. And then we're kind of like, we don't know where you are. So make it very clear. I always do that. Like I said, I started off by saying I got 4 points, and the first point was submission. Second point is about the case, and that's what I want you to pay attention to. Third point is this, cross-examination. It's really an art form, right? And if you're not willing to, if you're not sure where you're going with it and whether you end up opening a can of worms, be very, very careful. Right now, to me, when I first started practice, I used to write down all the questions. I have to 150 questions, prepared questions. But you know, when the second question is asked, the answers would come off and take you off tangent, right? So in the end, what I did is that I'll just look at the issues, or I'll look at the statements and just circle points that I want to ask, and then go down that path. And I don't care whether you give me a yes or no answer, because I know where I'm taking you down to, right? So it doesn't matter. So be careful how you start off, and you know, in the short time that you may have in major international arbitrations, the times are short. So no point asking them, so when was the contract entered into? We all know when the contract was entered into. Just go straight to the point. So that's the third point I want to make. And the fourth point I want to make is about summing up. Obviously, this is a competition, so you have very little time. And I thought both parties did, teams did incredibly well. Considering the short time and taking in the cross-examination questions, I wouldn't have been able to do what you guys did. But I thought you guys crystallized it very well and put it together. And then when you got interjected by us, you stopped for a minute and you were able to tackle those questions. So now remember that as well. You don't have to answer the split second we throw a question at you. You can do what, you know, a lot of international people say, oh, that's a very interesting question. That's an excuse for, let me think about it, right? And then think about it and then go back to your facts and all of that, and you'll find your answers there, right? So don't have to knee-jerk react to that and then do that. So, but I thought both parties, the submissions were quite well done in because of the time. So these are the 4 points I wanted to highlight. Very impressive when you guys got into action and got into gear. Thank you.
Thank you, Mr. Anil. I would request Mr. Ho to make his comments.
Thank you, Jindal and Anil. Yeah. First of all, I would just say that congratulate the BIAC on this very great initiative. This is a fantastic element in your progress. So I wish you well in the years to come with this context. Right. So Mr. Anil already covered several good points, and I think I certainly agree with him with all the things he said, including no, he's not being picky about being paragraphing. He talked about paragraphing and so on and so forth. Yeah, because I also spotted, I think, 2 typo errors along the way, right? So these are the things that shouldn't happen at this level, especially in the final typo error, paragraphing, putting of paragraphs and all that. So these are minor things, so-called, which could be, make your whole submissions more polished stuff. Okay, I have to say a few other things, and that is, well, Dr. Deepak has also mentioned this. The point is that, I think the respondent's argument is that, oh, the claimants have agreed to extension of time to pay, and therefore, why don't they agree to a downward revision as well? That kind of argument, yes, you cannot extrapolate like that, right? Because they agreed to defer the installment for quite a time, does not mean that they also have to agree to your request for downward revision, right? And on this point of downward revision, I wonder why both parties did not mention any part of the figures as to downward revision. They just talk about downward revision. It comes up my question: what is the figure? Because I would have thought there was room to scope to negotiate on the figure, right? How much is the downward revision talking about? After all, the clause 129 in the deal agreement says that the matter shall be discussed between the two parties and resolved immediately. So, so that could be something that work on and to discuss, of course, even before the investigation stage. So, we could have heard something perhaps on how how negotiations on that path went on. Instead of that saying, one party was saying, oh, we asked for downward revision, but the other party did not agree. So, to what extent was this done? How much was this done? Another point that I thought I'd like to mention is that I think I heard respondent commissioner that he asked in court examination, they asked the claimant, did you notice what would you have done if you as an ordinary person, would you buy property during the pandemic? So I think they were trying to get the answer that, well, they won't, that a normal person would not buy property during a pandemic. But I tell you, the fact of the matter is that in Singapore, at least, last year during COVID-19, the volume and the price of property actually rose. Both the volume and the price actually rose. So I'm not sure whether you will say about that, but I mean there must be some basis. If you want to say that because of the COVID, property sales went down, right? Because anecdotal evidence from Singapore actually shows the other way around. So the price and the volume of sales property actually went up. Okay? So having said all that, I don't take up too much time, but overall, as Anil has pointed out, both parties did very well indeed, right? So my congratulations to both parties. But of course, at the end of the day, there will only be one winner. And so on that note, I'll hand over to our Chief Judge now, Dr. Jindal. Dr. Deepak.
Thank you, Mr. Ho. Thank you, Mr. Ho. Well, before the declaration of results, I just want to express my feelings. See, it's always a pleasure and privilege to say that it's always a pleasure and privilege to participate in all these contests and other programs organized by BIAC. I have a special bond with BIAC. Last year also, I participated in their events, and I have been participating in this contest right from preliminary rounds to semi-finals and then now the finals. See, more so today with the eminent and very pleasant, great personalities of Singapore, Mr. Anil and Mr. Ho. They are very wonderful personalities and wonderful persons. Thank you very much, Mr. Anil and Mr. Ho, for such a nice coordination inter se, and great talent, great potential between both in both the parties. I would congratulate. I could see in all the participants, right from the claimants, all the claimants, the claimants team, the respondents team, the witnesses, the counsels. They were thoroughly revised, thoroughly prepared, and it was very difficult to judge for us to between as to who is the winner. I'll declare the winner later on. I had a lot to ask and suggest the participants, but due to lack of time, I would say just three things: that avoid asking multiple questions. That was pointed out by Mr. Anil also. Avoid asking multiple questions and support your arguments with your pleadings also. Support your arguments with your pleadings. Your arguments should not be pleadingless. It should have been mentioned in your pleadings. and say something which was there in the agreement, say something which is there in your written submissions or claim or written statement, whatever it is, whatever is there, you know, and that is all. Lot has been said by Mr. Ho and Mr. Anil, and be concise in your pleadings. Yes, it should be, it has to be there. Be concise in your pleadings. I'm a High Court as well as Supreme Court counsel. Judges also say there to us that be concise in your pleadings, because this helps the judges and in turn arbitrators also to come up with the facts of the case and observe both the parties and come up with their judgment, order, etc. BIAC is doing a great job. BIAC is doing a great job and organizing such seminars, conferences, contests, and which will in turn enhance the academicians, the professionals, and will also give a great impetus to this concept of arbitration. I would thank the sponsors also here, Citibank, and as truly said by Mr. Masroor Arfin, Mr. Rumi Ali, and Mr. Mehbubur Rahman, that these kind of contests and conferences will certainly, push the concept of arbitration and will in turn lessen the burdens of courts. I congratulate you once again. I thank Mr. Akmal and Mr. Rumi Ali in particular. Thank you very much. At the end, the results of the case, very difficult, margin of 2 marks only, but the winner is University of Dhaka, Bangladesh. Congratulations. Don't be disheartened, Mr. University of Chittagong. You performed very well. Excellent performance by both the participants. Excellent. Beyond this thing, beyond words, beyond description. Thank you. Congratulations.
Congratulations to the champion team of University of Dhaka and runner-up team University of Chittagong. As our contest is being held from a digital platform, BIAC has decided to conduct a prize-giving ceremony to hand over the champion and runner-up trophies and distribute the certificates to the students on 8th January 2022 at BIAC premises by maintaining social distance and necessary precautions for COVID-19. I'd like to conclude the session here by thanking the Tribunal's chairman and members of all the sessions of the contest and the team members of all 7 universities, along with their faculty members who worked hard to train and prepare their students for this contest. I'm Mahbuba Rahman Runa, General Manager of BIAC, was the host and coordinator of this contest. Thanks you all for being with us and making it a success. See you next year. Allah Hafiz.
Thank you so much, ma'am, for giving us the opportunity.
Allah Hafiz.
Thank you, judges.
Okay.
Congratulations to the Dhaka team.
Thank you, sir. Thank you, sir. Thank you so much.
Hey, good night, all. We'll take our leave. Thank you very much for an exciting afternoon and evening. Best of luck.
Thank you so much, sir.
Good night,
Thank you
sir.
so much. Good night. Good night.
Good night.
Thank you, sir.
Thank you and good night.